The Learned Counsel for the petitioner prays for listing this matter after
2 weeks, man.
2 weeks. The prayer is allowed. You have no objection. Okay. List this matter after 2 weeks. Yeah, you are Mr.
I, Jamir, I'm appearing from item number 48 to 54.
Okay. I, Jamil, Learned Counsel for the petitioner is present. Okay.
Lordship, I'm appearing from item 42 to 47.
42 to
47.
47. Okay, so in 42 to 47, her name also be, huh? Miss
It's agreed.
Learned Counsel for the petitioner is present, huh? Okay.
Obligation.
May Your Lordship.
May I please, Lordship?
Yeah.
My Lord, I want to mention one matter for unlisted matter, my Lord. Yesterday I filed it. So if it is possible, it can be listed today.
What is this matter about?
A anticipatory bail, my Lord.
Previous bail.
Yes, previous bail, my Lord. Yesterday I filed. Numbering is given.
Okay.
Today, my Lord.
Okay.
May I please, Your Lordship? May I be
Yes.
pleased to mention hearing item number 33, 34, and 35. 33, 34, and 35. Your Lordship, if the matter can come up after 2 weeks, Your Lordship,
You are
for the state respondents.
respondent.
Yes, Your Lordship.
So have you informed the Learned Counsel?
Your Lordship,
Okay. Miss
Enzolo,
Learned Counsel for the petitioner. Also Miss
Livica, Your Lordship.
Livika. Learned Government Advocate. Miss Livika, Learned Government Advocate, prays for listing this matter
2 weeks.
after 2 weeks, to which Miss Jamo, Learned Counsel for the petitioner, has no objection. Accordingly, the prayer is allowed. List this matter after 2 weeks. Okay.
Much.
Please, Your Lordship.
Yeah.
I beg to mention item 41 hearing.
Yes.
May I pray that I may be granted 3 more weeks
Two.
to receive instructions on behalf of state respondents.
Okay.
Lordship, I have no objection.
Okay.
Lordship.
Mr.
K. Arka.
Learned Counsel for the petitioner. Petitioner. You are for the petitioner
Yes, I'm for the petitioner, my lord.
in the opposite party here. No, just a minute. Huh? This is IA first.
Yes, ma'am.
Okay. Mr.
LD Sanctum,
Okay.
additional AG.
Learned Additional AG. Government of Nagaland. Prays for
3
Two.
weeks.
3
weeks time.
Pray for 3 weeks time and is granted 3 weeks time to obtain instruction. To which the Learned Counsel for the opposite party petitioner has no objection. The prayer is allowed. List this matter after 3 weeks. Okay.
Lordship, Lordship.
May it please your Lordship.
Yeah.
My Lord, I beg to mention here in item 31. Lordship, let this matter be listed on Thursday as a fixed item. Lordship, I have parties have a consensus prayer. 18 of April.
18.
Yes, my Lord. 18.
On the prayer of Mr.
This month,
The blue mark.
day after tomorrow.
Okay, Learned Counsel for the petitioner. The list this matter on 18.
Yes,
Lordship.
Okay, to which Miss. You have no objection.
No.
Okay.
It's
So-
a part hard matter, Your Lordship.
Okay, yes. I have no objection. Okay, list this matter on 18. That's fine only. Okay.
Much obliged.
Also, Lordship, I also beg to mention item number 14, Lordship. Here I am for the respondent number 4 and 5. Let this matter be listed after 3 weeks, Lordship. Item 14, Lordship.
You are for?
I am for respondent number 4 and 5.
Okay.
Let this matter be listed after 3 weeks.
So who is for the petitioner here?
Lordship. Empty launching.
You have no, any objection?
No objection.
No. Okay. Heard Miss
Catherine.
Learning Council for a petitioner. Also heard Mr.
W. Mahar, Lordship.
Learning Council for respondent number 4 and 5, who prays for listing this matter
After 3 weeks.
after 3 weeks. So the prayer so made by the Learning Council has not been objected to by the Learning Council for the petitioner. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
Lordship, I also beg to mention item number 11. Lordship, let this matter be listed after 2 weeks.
You are for here?
Here I am for the respondent number 3.
Okay. So who is for the
Lordship,
applicant?
here parties have a consensus prayer here. I've
Hmm?
taken the consent of the other party.
Okay,
Lordship,
Mr.
The appellant.
Okay. His name, Mr. Learning Council for the respondent with the consent of the Learning Council for the applicant. Applicant, huh? This is IA only,
Yes, Lordship.
prays for listing this matter after
2 weeks, Lordship.
2 weeks. The prayer is allowed. List this matter after 2 weeks.
Much obliged.
Okay.
May I please, Lordship. My lord,
Yes,
I beg to mention item number 9.
9.
My lord. My lord, here I'm entering appearance on behalf of respondent number 7, 14, 19, 24, 26, and 31. I'll be filing my particular number during the course of the day. So I may be allowed 3 weeks time to file my affidavit.
You are for the petition.
Yes, Lordship.
Heard, Mr.
Abel Ayemi.
Learning Council for the petitioner. Mr.
Taka Kichu.
Put appearance on behalf of the respondent number
7,
7,
14,
14,
19,
19,
24,
24,
26,
26,
and 31.
and 31, and prays for
3 weeks time, my lord.
3 weeks' time to file affidavit. The prayer is allowed. List this matter after 3 weeks. Okay.
My lord, I also beg to mention item number 2, my lord. Here I'm for respondent number 4. I may be allowed another 2 weeks time to file my counter affidavit.
Okay. So, our message, Land Council for the petitioner. Also, Mr.
Taka Kichu for respondent number
For
4.
respondent number 4, who prays for
2 weeks time, my lord.
2 weeks' time to file counter affidavit. The prayer is allowed. List this matter after 2 weeks.
Much obliged.
Okay.
May I please, Your Lordship?
Yes.
Lordship, I'd like to mention item 21 on behalf of Ajung Lee, government advocate. Kindly grant us 3 weeks' time to file our counter affidavit.
You're for the state.
Yes, Your Lordship.
No objection, Lordship. I'm for
No
the petitioner.
objection. Okay. Mr.
M. Longko,
Okay, appearing on behalf of
Ajung Lee, Sanctum.
Sancta, Land Government Advocate, sir, or advocate, prays for how much time?
3 weeks, Your Lordship.
3 weeks more time to file affidavit. It's an affidavit or counter affidavit?
Affidavit in opposition.
Affidavit in opposition, okay. To which Mr. His name, huh? Has, no, just a minute, huh? His name, is Mr. So-and-so, Land Council for the petitioner is also present. Who made no objection to the prayer made by the Land Council for the respondent. The prayer, accordingly, the prayer is allowed. List this matter after 3 weeks. This, I think, was specifically directed by this honorable court, this court, to file affidavit. No?
Yes, Your Lordship.
Okay, file. Yes,
Your Lordship, I'd also like to mention item 22 on behalf of Ms. S. Chang. Affidavit has been sent for vetting. So kindly list the matter after 1 week.
You are Mr.
Toshio Longko.
Toshi, okay. Mr. Toshi Longko, Longkumar Land Council for the petitioner is present. Mr. His name, Land Council for the respondent number.
For the
State respondents.
respondents.
Hmm?
For the state respondents.
Okay, no private respondent?
No, Lordship.
Okay. Prays for one more week time to file affidavit. The prayer is allowed. This matter after a week. Okay.
Obliged, Lordship.
And Your Lordship, I'd also like to mention on behalf of Miss S. Mary, Government Advocate, item 2. Actually, is having, sorry. Item number 3, Your Lordship.
Okay.
Your Lordship, I beg for your indulgence in item number 2. There was an interim.
In item 2.
Yes, Your Lordship. It was previously
In
mentioned.
item to come back to item 2. The interim order passed earlier shall continue till the next date.
Much obliged.
And in 3, who is for the petitioner? Have you informed the petitioner?
Yes, Your Lordship, within your consent. She's having personally difficulties after 1
Okay.
week, Your Lordship.
Mr. Appearing on behalf of Miss
S. Mary.
S. Mary, Land Council for
the state.
Land Government Advocate.
Yes.
Prays for listing this matter after
1 week, Your Lordship.
after a week. Stop. Miss, you are
Veto for the petitioner.
okay, 30. For the petitioner is present. Is prayed, comma, list this matter after a week.
Yes, Your Lordship.
Okay.
Your Lordship, I have similar prayer for item 3, 4, 10.
3 already mentioned.
Oh, sorry. 3 and 4, 10.
4.
3 and 4 are together, Your Lordship.
3 and 4.
And a yes.
Okay, 3 and 4. That is 4. 3 and 4, huh? And 10.
Yes, 10. Similar prayer on behalf of S. Mary, Your Lordship.
That's right. So here you have
I'm for the petitioner and respondent then. Item 10, Your Lordship.
item 10.
Applicant, yes.
Okay, the similar, you are Mr.
Supamati.
Okay. Supamati, huh? He made a prayer on behalf of Miss Larry, same order, huh? Similar order, only his name will change. So this will be after
1 week, Your Lordship.
a week, okay. Yes.
Your Lordship. Similar prayer again on behalf of S. Mary for item 12, 13, and 17. Your Lordship.
12, 13 and 17 also.
Yes, yes, Your Lordship.
So have you informed the Land Council for the petitioner?
Yes, except for 17, I couldn't locate the council. Your
Okay,
Lordship.
here again, similar prayer, and 12,
12 and 13.
13
are
and
August.
17 also, huh?
Yes, Your Lordship.
So in 12, 13 and you are in 12,
Your Lordship, I'm for the petitioner in 12 and 13.
12 and 13, huh?
Yes, Your
Similar to that order. And who is for the petitioner in 17?
17, I could not locate, Your Lordship.
Okay, so then on 17, so have you informed? No,
No, not
you
yet.
could not. Okay. So let this matter be called. Surjit Pauner is not present. Okay.
Yes.
Are you in 17?
Yes, no objection.
Okay, in 17, her name. Huh. Okay, okay.
Obliged, Your Lordship.
Your Lordship, may I please mention item number 37 for hearing?
$37,
Yes, Your Lordship, I pray this matter be listed after 2 weeks.
you are for petitioner.
Yes, I'm for the petitioner.
I'm
Okay.
for respondent of 2, 3 and 4.
Okay, Miss, you're tossing, eh?
Veto.
Oh, sir, V30, Land Council for the petitioner. Praise for listing this matter
2 weeks, Your Lordship.
after 2 weeks.
Like my lord.
My Lord, there's an interim. It can kindly be
Mr.
extended.
Paseco for the Land Council for the respondent number 2,
2, 3 and 4.
no, 2, 4 and 5.
2, 4 and 5, Lordship.
Hmm.
My apologies.
He is also present. He has no objection to the adjournment prayer made by the Land Council for the petitioner. Stop. Accordingly, the prayer is allowed. List this matter after 2 weeks. Stop. The interim order passed earlier shall continue till the next date. Okay.
May we oblige?
May I please, Lordship?
Yes.
Lordship, I beg to mention number 5 and 6, Lordship. I'm for respondent 5 and 6.
So,
Lordship,
have you-
let it come up to 2 weeks, Lordship.
have
My
you
senior-
informed the
Yes, Lordship. The petitioner is here.
okay. Mr. In-law, land counsel for the petitioner. Staff. Also, Mr. Posego Forte, land counsel for the respondent who prays for listing this matter after 2 weeks.
Lordship.
The prayer is allowed. List this matter after 2 weeks. Okay,
Lordship, I have similar prayer for item number 7.
7 also.
Lordship, I'll be filing my reply within a week. Lordship, kindly let it come up after 2 weeks, Lordship.
So who is here for the petitioner?
I'm for the
You are for-
petitioner. I'm for the petitioner, Lordship. I'll be
You're
filing my
petitioner
reply.
here.
Yes, Lordship. Here I'm for the petitioner.
Okay, so who is for the respondent?
I'm for the respondent, my lord.
You're for, okay.
But let this be the last chance, my lord, because on several occasions we have served time.
Lordship.
Mr. Posego, the land counsel for the petitioner prays for 2 weeks' time,
2 weeks time.
2 more weeks' time
To file reply.
to file reply to the affidavit filed by the respondent staff. Mr. Longkumar is also present staff. Is prayed, list this matter after 2 weeks.
Lordship is an interim. Kindly let him continue,
Stop,
Lordship.
The interim order passed earlier shall continue till the next date. Okay,
Well, this may be the last chance because this may be reflected because
Lordship.
earlier also given opportunity.
Lordship.
on several occasions.
Okay. In the above, okay, this may be last chance, but this may be last opportunity for the land council for the revision petitioner to file reply to the reply. Okay,
Lordship, we allowed to mention item number 36 from the hearing list, Lordship. 36, I'm for the petitioner. Lordship.
okay,
Lordship, let it come up on Tuesday, as per the convening of the council for the respondent.
Lordship, yes.
okay.
Do you need
Eight
her to
praised for by the land council for the petitioner, Mr. Posego Forte and Miss
Gates agree.
for
On behalf of City Jamil.
appearing on behalf of City Jamil, land senior advocate, land council for the, Miss land council for the
Respondent.
respondent.
Respondent
List
number
is-
5.
Okay, respondent number 5, list this matter on
23rd, Lordship.
23rd.
Signature,
Okay,
Lordship. Highly obliged, Lordship.
May I please the Lordship, I beg to mention item number 9, Lordship.
9,
Lordship,
yes.
here, Lordship, the state is yet to file counter.
9 already mentioned someone mentioned,
Lordship,
so probably respondent number 7 has mentioned,
okay. Item number 16, Lordship.
16,
Lordship,
okay.
the state is yet to file counter. Lordship, kindly grant 2 weeks time. Lordship.
So, you are for the petitioner,
Yes, Lordship.
okay, Mr. Land counsel for the petitioner is present. Mr. Jimomi. Land counsel for the state respondent prays for 2
2 weeks time.
2 weeks, 2 more weeks times to file affidavit.
Lordship,
Okay, the prayer is allowed. List this matter after 2 weeks. Okay,
Lordship, I also beg to mention item 23, Lordship.
23.
Lordship,
Okay.
here, I'm yet to receive instruction, Lordship. So if Lordship may please grant 2 weeks time.
CD was also not called for here in this case. Probably it appears. Who is who is for the petitioner?
Lordship, I'm going on behalf of my senior, Philip Loring.
Okay. So status report also next time you,
Lordship,
just a minute, huh?
Lordship.
CD was also probably not called for. Kindly, 23, item 23. You are seeking time for what? What
Lordship,
purpose?
To get a case diary, Lordship.
Okay,
Status report, Lordship.
hard miss,
Berta Tep.
I count for the petitioner. Stop, huh? Mr. Jimomi, Lana PP. Praise for how much time you said?
2 weeks time, Lordship.
2 weeks time to produce the scanned copy of CD, scan.
Lordship, on the last occasion that was not mentioned, however, Lordship, to produce the status report.
Okay.
Actually, Lordship, the petitioner and the complainant, they have come to a compromise.
There,
They have come to a compromise deed, Lordship.
yes, it appears. That is what,
So,
opportunity
yes.
was given. Okay.
Yes, Lordship.
Two more weeks to produce the case diary, huh? Stop, huh?
Lordship.
No, just a minute, huh? Mhm. So we'll say, call for scan copy of case diary.
Lordship,
Okay.
Lordship, that was
Charge sheet not yet filed, probably.
probably.
Hmm. Call for the scan copy of the charge sheet, huh? List this matter after 2 weeks.
Lordship.
Okay.
Lordship, I also beg to mention item 25. Item 25, Lordship. It's
25.
the order, Lordship.
Yes.
25 and 26, Lordship.
Hmm?
25 and 26, Lordship. It's in the order, Lordship.
Yes.
Lordship, here as far as state respondent is concerned, Lordship, we are here to file affidavit in opposition, Lordship.
Lordship, in this case, I may also be allowed to take the first steps. The respondent number 4 is not.
Okay. So are you going, you have urgent work? Are you not in a court?
Lordship.
Is it short or the order?
Actually, I'm not keeping well, Lordship.
Okay, it
Because
appears,
of-
it appears, yes, okay. Mr.
H.H. Kinimi.
Planning Council for the petitioner prays for how much time? 2 weeks time?
3 weeks
To
time,
take
Lordship.
3 weeks time,
Yes, to take the first steps.
to take fresh steps upon respondent number
Number 4.
Hmm?
4.
4.
Yes, Lordship.
The prayer is allowed. The Mr. Jimomi, Planning Council for the state also prays for some more time to
Lordship.
file affidavit.
Affidavit in opposition.
Affidavit in opposition. Is prayed for by the Land Council for the parties. List this matter after 3 weeks. This is 25 and 26.
Yes, Lordship.
Okay.
Yes. Obliged.
Mr. Lordship,
Yes,
I'd like to mention item number 40.
14.
Your Lordship, if this matter can be listed after 2 weeks.
14, I think someone already mentioned.
40
40.
for respondent number 5 and for respondent number 5.
And who is, you are for the petitioner?
Lordship, I'm for the petitioner.
You have no objection.
No objection, sir.
Is prayed for by the Land Council for the petitioner as well as the, after?
2 weeks, Your Lordship.
Okay, Land Council for the petitioner, Miss so is present, huh? Stop. Miss
Shista Jamir,
Land Council for the respondent number
respondent number 5, Your Lordship.
5, prays for to file affidavit.
No, for hearing, Your Lordship.
Okay, this is for hearing only.
Yes.
Okay. Okay. Prays for listing this matter after 3 weeks, to which the Land Council for the petitioner has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
Bless, Lordship. Your Lordship, I also like to mention item number 32.
3-2.
Yes, Your Lordship.
Yes.
If this matter can be listed next week, Tuesday, Your Lordship.
Okay. Tuesday.
Mm.
And then you are for the petitioner.
Yes, Your Lordship.
And who is for the respondent?
I'm appearing on behalf of my senior and Longkumar. We are for respondent number 1, 2, and 6, Your Lordship.
1, 2, and 6. No objection.
Yes.
Okay. Miss
Shista Jamir, Your Lordship.
Land Council for the petitioner prays for listing this matter after
On Tuesday, after a
on
week.
Tuesday. Tuesday. To which Miss
SPN.
appearing on behalf of Mr. C.T. Zamir, Land Senior Advocate, Council, Land Senior Council for the respondent number 1, 2, and 6 has agreed now. Has no objection. Staff, accordingly, the prayer is allowed. List this matter on Tuesday for hearing. Okay.
Much obliged, Your Lordship. Much
May I please, Your Lordship?
Yes.
Lordship, I beg to mention admission item number 20. Lordship, here the writ petition was preferred.
with a prayer to consider my case for regularization.
Hmm.
However, Lordship, during the pendency of this petition, the authority respondent has taken a decision. That is by order dated 12/3/2024. I have been terminated from service. Thereby, the matter is already infectious now, Lordship. Therefore, I may be allowed to withdraw this case.
Okay. Mr.
Ali Walzukum, Lordship.
Learned Counsel for the petitioner submits that during the pendency of this writ petition, the respondent authority has already terminated the petitioner from his,
Service, Lordship.
this is what service?
Okay, JSCO, Lordship.
Okay. service.
JSCO.
JSCO staff. Huh? And as such, the matter has become infructuous. Accordingly, he wants to, accordingly prays for allowing him to withdraw this writ petition. The prayer is allowed. You have anything? No.
No, Your Lordship.
Okay. Mr. Angami, the senior counsel,
Lordship.
he is present. Huh? Is this writ petition is dismissed on being withdrawn.
Lordship, may be disposed of.
Disposed of.
Yes,
Okay.
Lordship.
On being withdrawn. Okay.
Duly obliged, Lordship.
Obliged, Your Lord.
Okay.
May I please, Your Lordship?
Yes.
I beg to mention item number 8. Your Lordship, kindly grant us 3 weeks time to file a reply. Item number 8.
8.
Yes, Your Lordship.
So what do you want?
Kindly grant us 3 weeks time to file a reply.
3 weeks time?
To file a reply.
Okay. Okay, Miss
And solo.
Learned Counsel for the petitioner prays for 3 weeks time to file reply to the affidavit filed by the respondent. Your objection. Okay. So, Mr. Learned Counsel for the appear on behalf of the state.
Your Lordship, there's an interim.
And has no objection to the prayer made by the Learned Counsel for the petitioner staff. Accordingly, the prayer is allowed. List this matter after 3 weeks. Stop. In the meantime, the interim order passed earlier shall continue till the next date. Okay.
Your Lordship, I have a similar prayer for item number 15.
Item 15.
Yes, Your Lordship.
There also you have interim.
Yes, Your Lordship.
Okay. So you are for respondent?
Respondent 1 and 2.
1 and 2.
Yes.
Ms. So-and-so, Learned Counsel for the petitioner, prays for 3 weeks time to file affidavit in reply. Stop. Miss Learned Counsel for the respondent number
1 and 2.
1 and 2, and Miss
And for respondent number 3.
for respondent number 3 are also present. Stop. As prayed, list this matter after 3 weeks. Okay.
Your Lordship, interim.
In the meantime, the interim order passed earlier shall continue till the next date. Okay.
Lordship.
Yes.
May it please your lordship, yeah, I beg to mention item number 1. Kindly give us 2 weeks time to file our affidavit in reply, your lordship.
3 weeks time
2 weeks time.
to file affidavit in reply.
Yes.
Okay. So this is first item. It will be called.
Yes, your lordship.
Let it be called. Your matter will be called only now. Any other item? Okay. Miss Learned Counsel for the petitioner prays for 2 weeks time to file affidavit in reply to the affidavit filed by the respondent. Stop. You're from.
And for respondent number 4, Lordship,
Okay, Mr.
Abel Ayemi.
Learned Counsel for the respondent number 4 is present. Staff is prayed. Sorry, the prayer made by the petitioner is allowed. List this matter after 3 weeks. 2 weeks.
2 weeks.
2 weeks. Okay. Yes.
Your lordship, I also have a similar prayer for item number 18 and 19. It's an analogous case. We're yet to
file affidavit in reply. Kindly give us 2 weeks time.
Okay. Ms. So-and-so, Learned Counsel for the petitioner. Prays for 2 weeks time to file affidavit in reply. The prayer is allowed. This matter after 2 weeks. Okay.
Mr. Blush.
Lordship, in item number 25 and 6, it's already mentioned, but I forgot to pray for the interim.
Interim is
There
there.
is an interim, Lordship.
Come back to 25 and 26.
This interim may be continued.
The interim order passed earlier shall continue to the next stage. Okay,
Obliged.
yes.
From the supplementary cost list for motion, item number 55.
Yes.
Lordship, this petition has been moved by 3 petitioners, Lordship. Petition number 1 and 2 are the brothers of the 2 deceased children, Lordship, who were killed during the shootout. Indiscriminate firing by the 46 Assam Rifles and 12 para commanders, Lordship, in the year 2015, 16 July, Your Lordship. Petition number 3 is a surviving victim who has been permanently injured during the indiscriminate firing, Lordship, by the state respondents. And so they're approaching this court because it has been more than 8 years. No action has been initiated, Lordship, to bring justice. So, Lordship, compelled by the situation, they are under constraint to approach this honorable court, praying for remedy, Lordship. Lordship, I'll just take you to the brief facts of the case. Lordship, on 15 July 2015, Lordship, there has been a shootout between the NSCN-K and between the 46 Assam Rifles and 12 para commanders, Lordship. So during that shootout, Lordship, 2 NSCN-K cadets were slain. So on the next day, Lordship, 16th July 2015, as they were transporting the dead bodies of the 2 slain cadets, Lordship, the villagers of Luzon gathered together because it is, Lordship, it is a customary practice at Lordship that although these people were, the 2 cadets were slain, since one of them hailed from Luzon village, so they requested, they wanted to give a proper burial to the deceased, Lordship. So, Lordship, as the convoy were passing by,
They belong to the said village.
yes, Puhachu was a deceased, Lordship, one of the deceased who hailed from Luzon village, Lordship. Now, what happened is that,
It's in the
Lordship,
stage why I have serious objection in this case.
Lordship,
Because
I can't allow me to ask,
there
Lordship.
Civil revision filed before this court,
Civil
which is
revision.
pending, civil revision.
Lordship,
Earlier filed.
Lordship, no, they have
There is a civil revision.
are here, Lordship. The
It's
petitioners,
all and after talk because it's after 9 years they are approaching this court. After the incident, it's 9 years.
Just a minute, let her complete the basic one.
Lordship,
Civil
yes.
revision filed.
It is not filed by the petitioners concerned, Lordship. We don't know who has filed it, Lordship. We,
After that incident, whether FIR filed,
FIR was filed, Lordship. No action was taken because
registered.
it was not registered. Till date, we are not, it is not in our knowledge, Lordship. Because under the Armed Forces Special Powers Act, prosecution sanction is required to, the central government needs to give sanction.
You have annexed the FIR.
Lordship, yes, we have annexed the FIR. No action is taken, that's why,
Where is the FIR?
Lordship. Page 79, Lordship. On the same day of the incident, the villagers have filed the FIR. Highlighting the facts of the case, Lordship, in detail. These are the detailed accounts, Lordship, of the witnesses who were present in the incident, during the incident, Lordship. If you would kindly allow me to read it, Lordship.
Yes.
To the officer in charge, Mallory Police Station, subject first information report on firing and killing of 2 civilians at Wuzu village on 16 July 2015 by 46 AR C Core under the Major Surrender Singh. Sir, with the eyewitness of the final incident and killing of two innocent civilians, namely one Mr. Tuzali, age 14, son of Sukahol of Poor Village, two Ms. Aso, age 13, daughter of T. Yetili of Wuzu Village. Both the deceased are class 7 of students of government school Polari. Also injuring one woman, Mrs. Vitsuro Esther, wife of Mr. Rutu of Wuzu Village by Unit 46 AR Sepoy under command of one Major Surrender Senior Post Commander Akego Post state the following points. 1. On the fateful evening of 16th July 2015, around 6:30 p.m., the native and public of Poor Village, Poor and Wuzu gathered at Wuzu Village for receiving information that the relative remains of late Puhachu of NSCMK killed on the night of 15 July 2015, who happened to be a relative of Wuzu Village, was being taken to Ranari via Wuzu Village to request the Assam Rifle authorities to hand over the relative remains of late Puhachu to relatives at native village itself. The relative and public had already prepared 2 coffins for both dead body cadres of NSCMK. The 5 vehicles convoy under the command of Major Surrender Singh were requested by relatives to stop. Out of the 5 vehicles in serial number or serial order, 407 truck, Gypsy, Tata truck, 407 truck, and 407 truck. 3 leading vehicles stopped near Community Hall. 4th vehicle with Major Surrender Singh and last vehicle stopped outside residence of Sri Ichuli, Lance Nayak, Village Guard, Wuzu Post. The village elders were acquainted with Major Surrender Singh and requested him to hand over mortal remains of late Puhachu. But Major Surrender Singh expressed his inability, for which the relatives requested the Major to accept the already prepared coffins built for the deceased. While village leaders were interacting with Major Surrender Singh seated inside Ford 407 truck, the occupants of leading vehicle Gypsy started firing, and after which the occupants inside vehicle of Major Surrender Singh started heavy firing, as also occupants of last vehicle on the left of road Wuzu to Malari outside the residence of Sri Yichuli. Before the firing, during the firing, and after the firing, the public in no way provoked the security forces, nor pelted stones or any missiles or use of firearm. The plea of village elders known to Major Surrender Singh to cease fire in view of unprovoked firing at the women, children, and public went unheeded, and firing continued for nearly 20 minutes, after which the security personnel under the command of Major Surrender Singh fled the incident site. The aftermath of such incident, unprovoked ceasefire firing resulted in the death of 1. Mr. Tuzali, son of Sukoho, age 14 of Poor Village, a student of class 7 Government High School, Polari, outside residence of Sri Lachunan. 2. Ms. Aso, daughter of T. Yetili, age 13 of Wuzu Village, student of class 7 Government High School, Polari, inside Sri Lachunan residence, and Nigerian Mrs. Vitsuro is the wife of Rutu of Wuzu Village, age 24, mother of 1 child outside Sri Lachuna's residence. Major Surrender Singh, in Patan, having fled the crime, saying, called at Chennai, Poor Village, Sri Chennai for Liberal, number 8732899987 at 7:14 p.m. as per mobile record, and Chennai Wuzu Village, Sri CP22 for the same number at 7:28 p.m. as per mobile record. The accused villages of joining hands, which leads to ambush security forces. The group of village children clearly stated the Major Surrender that it was forces under pursuit plan of Major Surrender Singh who carried out unprovoked firing on innocent villagers, resulting in the death of 2 children, injuring 1 mother, and loss of properties. It is a Malari spot verified incident site around 9:30 p.m. of 16 July 2015. After the firing incident, the villagers with the ABC Malari and OC Malari police station recovered a total of 143 empty shells from the firing spot. We, the following village elders, therefore append our signature in witness of the incident for necessary action. So these are the signatories, Lordship. Sri Kotu VCC, VG Commander Wuzu, then Head GB, Poor Social Action Committee, VCC New Poor, Head GB Blue Poor, VCN Poor, VCM for another, then another VDP secretary, then another VCM. These are the complainants, Lordship. Lordship, over the years, Lordship, before I jump to the case, Lordship, I also would also like to bring it to the notice of this court that at the time of incident, when the incident was very hot, Lordship, was burning, it was the Nagamadus Association who have approached the Honorable Supreme Court, Lordship, by way of filing writ petition.
What association?
Nagamadus Association.
Okay.
They have filed a writ petition criminal before the Honorable Apex Court, Supreme Court, Lordship. But that petition was withdrawn, right order 14th September 2015. In the withdrawal order, Lordship, the Supreme Court has clearly directed, because they have withdrawn with a prayer that they were with liberty to file appropriate high court. So the Supreme Court, Honorable Apex Court, has given a direction that it is, Lordship. Allow me to please continue, Lordship. So the Honorable Supreme Court clearly stated that, Lordship, as in when the matter is filed before the Honorable High Court, then the matter should be heard expeditiously. Those in merits of the case, Lordship. Lordship, the order is very clear. Yes, the petitioners are different, but the issue is same, Lordship. The issues are same. Same incident has been reported. Same with similar prayers. But the thing is, since we have the High Court here, then the Nagamadus Association also thought it would be appropriate before approaching the Honorable Apex Court. The appropriate High Court has been approached, Lordship. So, Lordship, the petitioners are not barred from, Lordship, approaching this court, Lordship. It is not your fault that 8 years have passed and no justice, no action was taken. It is not in their hands, Lordship. So that's why they are before this honorable court. Now, Lordship.
Just a minute.
Lordship, yes.
Naga Mothers Association.
Yes.
This petition was filed for the same incident.
For the same incident, Lordship. For the same incident. In fact, I have enclosed your order, Lordship.
Yes.
I have enclosed your order. No, Lordship.
The fact
I can also
produce. Same.
Yes, facts are same. I can also produce the copy of the petition, Lordship, on the next date, if it is required, Lordship. It can be placed before this honorable court.
Disposed of in the year?
In the year 2015, Lordship.
So why now then?
Page number 48.
This was disposed of in the year 2015.
Yes, Lordship, because the petitioners have.
After you did not file.
We have not filed because we were waiting. We were waiting the prosecution sanction will be given, Lordship, and then the law will take its own course. But till date, nothing was done, Lordship. So what do we do, Lordship? We were also not given adequate compensation, which.
By this order, it says, as and when such the writ petition is disposed of or withdrawn with the liberty to the petitioner to approach the High Court.
Yes, Lordship, by filing appropriate petition for appropriate release.
In time till since 2015 till date, so you did not file any.
We have not filed it. Yes, because we had hope. Yes, we have not filed, Lordship.
Okay.
We were hoping that the respondents will at least remedy the wrong, Lordship, and take accountability. We were hoping, Lordship.
Okay, you did not file, but have you taken any steps for requesting the government,
Lordship, yes, even the village, even the students' leaders.
Register the case.
Lordship, the village students' leaders constantly been pursuing with the government also, Lordship, to do something. And also, Lordship, I would like to bring it to the notice of the court. An inquiry commission was set up, Lordship.
Okay.
So the state government informed that inquiry commission was set up. So let the report be submitted. So, Lordship, we heard that it was already submitted to the government. That's why I have an interim prayer, Lordship, for the proper adjudication of this case to assist this court, Lordship. If inquiry commission report can be placed before this court, the state government may be given directive, Lordship.
Inquiry commission for?
To investigate, Lordship, to look into the matter, Lordship. Let me take you to the order, Lordship. Page number 96, Lordship. Page number 96.
Yes.
Yes, Lordship. I may be correctly allowed to read, Lordship. Government of Nagaland, Home Department, Political Branch. Dated Kohima the 13th November 2015, number COM/LOR 3/2012. Whereas on 16 July 2015, 146 Assam Rifles and 12 paracommanders returned from Avankul area under Nagaland subdivision, Third District, after encounter with NSC and cadres in which two NSC cadres were killed and the dead bodies were being taken to Nagaland police station for legal formalities on their way in village. The village leaders of Mizo, all poor and more poor, requested the dead body of Forces Captain Pugachi of Mizo village to be handed over to them to manage. The commander of the security forces refused, after which incident of violence took place, resulting in the death of two civilians, both class 7 students, namely Tuzali, son of Sukhaho of Poor village, and Miss Aso, daughter of T. Yetami of Mizo village, an injury to one woman, Mrs. Mitsuho Esther, wife of Mutu of Mizo village. And whereas the governor of Nagaland has taken a very serious view of the incident and is satisfied that it is a definite matter of public importance involving law and order in the state, and the matter requires a detailed inquiry into the causes and circumstances leading into the aforesaid incident, and also to find out the persons responsible. And whereas the governor of Nagaland thinks it fit to constitute a commission of inquiry to inquire into the causes and circumstances leading into the casualties at Windsor Fire incident on July 16, 2015. Now, therefore, in exercise of the power conferred by subsection 1 of section 3 of the Commission of Inquiry Act 1952, 60 of 1952, the governor of Nagaland hereby appoints a commission comprising a single member, Mayor Shri Vapasaneka, a retired district and session judge, to be called Windsor Fire Incident Inquiry Commission. The commission shall make an inquiry with respect to the following terms of reference. Number 1, the causes and the source of firing, which led to the death of 2 minor children and injury to 1. Number 2, the persons responsible for the firing. Number 3, whether the incidents could have been avoided. The committee shall submit its report to the state government within 1 month from the date of publication of this notification. The headquarters of the committee shall be at Chumukadima. This supersedes this department's notification of even number dated 10th 2015, Lordship.
Okay.
Prior to this, one commission was set up, but then with this, this freshly constituted on 13 November 2015, the 10th August commission that was set up has been superseded, Lordship. So, Lordship,
whether the earlier commission has submitted any report?
So, Lordship, the earlier commission was, since this commission has superseded,
Okay.
Lordship, perhaps the inquiry could not be completed.
Okay.
Maybe some
Whether this commission has
it has submitted its report. That's what has come to our knowledge. We tried to obtain a copy, but we were not given, Lordship.
this was in the year 2015.
This was, no, after Lordship, I think very recently, the commission report was submitted. That's what,
No, direction was to submit report with
yes, within 1 month, Lordship. But we don't know what has delayed the submission of the commission report, Lordship. But Lordship, the first meeting of the commission was also held on 24th November 2015. Thereafter, eyewitnesses were called in by the commission to submit in affidavit, Lordship, which I have also enclosed in the following subsequent pages, Lordship, submitted by the eyewitnesses, Lordship.
What submitted by?
Starting from page number, Lordship, 100. These are the affidavit, in affidavit, statement in affidavit, duly authorized, submitted by the witnesses to the commission, Lordship.
So it was at the instance of the commission.
Yes, Lordship.
It was not recorded by the commission. But
This is the one we could get access to, Lordship. These copies we could get access to because the others, since the commission report, we will not furnish a copy. Our hands are tied, Lordship. But the state government, since it has been submitted, they can produced it, Lordship, before this court.
These are the declaration of the witness.
Yes, they were called in to submit in affidavit,
Whether the
Lordship.
commission has recorded a separate statement of the witnesses.
Lordship, that is not in my knowledge, but Lordship, if you would kindly turn to page number 98.
Yes.
These are the acknowledgement
By
by the ministerial staff of the commission, Lordship. Acknowledging the receipt of the affidavit.
okay.
Judicial Inquiry Commission regarding Wuzu firing incident on 16/07/2015. Camp Kedima Police Officers Central Mess, Dimapur, Nagaland. Number JIC -WFI/NIL dated Chumukedima the 19th July 2016. Received 18 numbers of affidavits / written statements from individual witnesses of Wuzu and poor villages besides Pachuri Students Union on this day, the 19th July 2016. Here at the Office of Judicial Inquiry Commission regarding Wuzu firing incident on 16/07/2015.
So your prayer is?
My prayer is to award adequate compensation, Lordship.
Okay.
And also to direct the respondents by issuing appropriate writs to grant prosecution sanction to the erring officers, Lordship, so that they can be tried as an ordinary citizens, as per in accordance with the procedure established by law, Lordship.
Okay.
So prayers are simple.
Okay.
Prayers are simple.
So
Lordship,
it appears that
all the allegations are misleading. There is an FR where the unit have filed a civil revision before this court, which is numbered as civil revision 7 of 2022.
Civil revision.
Yes, Lordship. And they
against
the state.
Or the civil
Against
revision.
the state because under the Special Armed Forces Special Power Act, Section 6, specific sanctions should be obtained from the central government to prosecute an armed forces, which has not been obtained.
The civil revision is against which order?
Against the concerned officer or against the armed forces employee, a sanction should be obtained, which has not been obtained till date, which they have not received till date. In order to prosecute armed forces, sanctions should be sought. They have not sought a sanction so far.
That is why we are here before this court with a prayer, Lord.
And they are saying that no compensation has been paid. Lordship.
We are not saying that.
No, they are saying that compensation has not been paid. I will show you the documents, Lordship. Page 3, Lordship.
A copy
My
page
question
also
number
can
one
be
to,
furnished.
para 3, page 3, para 3. In this regard, it may be stated that the state government has extended monetary relief to all the victims, including also those who suffered damages to their properties in the incident, right, so and so. So they have been compensated. Properties that has been damaged also be compensated, Lordship.
We're not denying that ex gratia was granted in 2 installments, Lordship.
So, Lordship,
but we are praying for adequate compensation. That is the
we
difference,
have
Lordship.
paid 5 lakh each. It has not been mentioned here in the letter, but I can produce the documents. I may be allowed to file my affidavit, Lordship. And
so okay, we'll issue notice.
yes, Lordship.
You file this in affidavit form.
Yes, Lordship. I'll file it. Lordship, I'll be appearing for reciprocal number 1, 2, 5, 6, and 7. 8. 8, sorry. 1, 2, 5, 6, and 8.
May I please, Lordship?
Yes.
I'm appealing for response number 3, 4, and 7.
Okay. Miss Keto Kojo,
Yes, Lordship.
Madam Counsel for
Petitioners.
the petition. Also heard. Mr.
E.T. Papon for the state respondent. 3, 4, and 7.
Okay. 3, 4, who's name first?
And Yang Rawati for
Hmm.
CCC for
For
One.
respondent number 1, 2, 5, 6, and 8.
8. Yes.
And 8. For respondent number 3, 4, and 7. Star. Para. By filing this petition under Article 226 of the Constitution of India, the petitioner prays for the following direction. 1. To the Union of India, direction to the Union of India. 1, to accord prosecution sanction to the erring officer of the Uzu firing incident involved in the unjustified killing of the 2 innocent children. Aso and Tuzali, and injuring petitioner number 3 in order to proceed with the investigation of the case in accordance with the procedure established by law. Start 2. Roman 2. Pass an order of adequate monetary to pay an adequate compensation. You have mentioned the amount also
Lordship, we have mentioned, Lordship.
of rupees 50 lakhs each in favor of the petitioner number 1, 2, 1 and 2. One, 2, and the and 1, 2, and 3. Then 1, 2, 1 and 2, 4. Death of 2 deceased persons. And to respondent number 3, for the permanent injury inflicted upon her. Stop. Any other prayer? That much.
That is all, Lordship.
Okay.
Any other appropriate, orders as this court deems fit, Lordship. Also, I have an interim, Lordship.
Interim
prayer.
for what?
Interim prayer, praying for placing the report of
Lordship, in the
Yes,
civil.
please.
Of the Musu Fan
Lordship,
Incident
in the
Inquiry
civil
Commission.
revision, there is already a stay order passed by this honorable court.
Is it?
In civil revision number 7 of.
Civil revision is pending before this court.
Pending before this court, Lordship, pending before this court, there is already a stay order.
Lordship, I am told that
Stay for what? Stay for? Stay saying what?
Stay that, staying the, proceeding of the lower court.
Some
district court.
proceeding
Proceeding of the, Lordship.
I think
What
Lordship,
kind of
the council
proceeding?
is confused.
There is an FIR pending, so proceeding is going on, criminal proceeding is going on, which has been challenged
proceeding against whom?
against the Assam Rifles, Lordship.
That is in
So
connection
that is
with
why,
which case?
that is
This
why,
case?
Lordship, I may be
No, in
related to
connection
this case, related to this case.
But
Same
in this
incident,
case,
same incident, Lordship, same incident, this case.
another FIR.
There is an FIR, Lordship,
No, not this FIR.
same FIR, Lordship, same.
It was registered.
Yes, it was registered
says
and
that-
it is
Lordship,
stated.
I said it's
That
not in
FIR
my
is
knowledge,
state,
Lordship.
Hmm?
It's not in my knowledge whether the FIR is
They should have-
registered.
Sorry.
But Lordship, that is immaterial
approaching this
because
court,
unless
there is
prosecution
always-
sanction is
there-
granted,
Just a minute, FIR registered.
FIR is registered
Hmm.
and
Case also investigated into.
investigated.
Charge
And
is
it was
submitted.
challenged. It was challenged before this court, and it has been stayed by this court, Lordship. On the next step, I will produce the order also. Same case, same FIR, same incident.
as far as I've been instructed, Lordship,
Hmm.
the respondents were challenging the commission, Lordship, that was constituted, Lordship, which was, single bench has discord,
Lordship,
single bench has dismissed the
this,
petition.
The order, copy
Yes,
of the order.
I don't have the order now, Lordship, but that civil revision was filed by the respondent number 6. in
Why,
pres-
why civil revision?
That was filed by respondent number
Civil
2.
revision.
Criminal revision, I'm
Should
sorry,
we,
was filed by this respondent speaker, this is Inspector General of Assam Rifle, IGR. So the proceedings have been stayed.
Okay.
On the next step, I will produce the order, Lordship.
You have the
Yeah.
number also.
7 of 2000.
And you are connected with this case?
If you look at the commission or the lordship, I want to tell you certain facts. about
Just, I just wanted to know whether a case has been registered.
Yes, sir. So there is GR number 46/15, which was registered under the District Court of Fake, sir, wherein the cognizance was taken by the court with the FIR that was filed, sir. However, as per the section of 6 of the Special Assam Rifles Act, sir, there is a prosecution sanction that has to be taken. Therefore, a criminal revision was filed before the Honorable Court, sir, wherein it was stated that the cognizance has been taken in the lower court without that prosecution sanction.
So cognizance already taken.
It is the cognizance of the case has been taken, that is pending in the District Court of Fake, sir.
Okay.
Your Lordship.
After taking cognizance, whether the case was charge was framed against the accused person?
Yes, yes, Your Lordship. However, it was stayed by this Honorable Court
Okay. So
because the prosecution sanction was
at what stage it was stayed?
it was on initial the initial stage, sir.
Initial, after framing of charge.
Right, right, Your Lordship.
Before recording of evidence.
Yes, Your Lordship.
Okay. So what are the offense registered against the accused persons? How many accused persons are there in that?
There are 2, sir. Your Lordship, Major Surinder Singh
And
and
okay,
another. However, there was an initial criminal revision that was filed by the officer itself. Later, by the Honorable Court, it was suggested that since the individual was on official duty, therefore the case must be filed by the organization per se. So a new criminal revision was filed by the number of 7/2022, wherein the same prayers were taken. That is, the prosecution sanction may be first taken, and then the
Okay. Anyway, so you file an affidavit and
Lordship, my prayers are not conflicting. My prayers are not conflicting with the cases that she just highlighted, Lordship.
if you say that charge, the
Lordship,
case has not yet been registered.
because that is not in my knowledge. These are poor petitioners, Lordship.
So if the case is pending before the
Lordship, the orders,
before the court, pending before the court.
This is your
relevant
case.
orders may be placed before this court, Lordship.
All the facts.
Relevant orders may be placed before this court, without confusing this court, Lordship.
No, because if the same FIR has already been registered and filed, and after completion of the investigation, charge sheet filed, and the trial also began, you're supposed to know as a
Lordship,
petitioner because you are representing the client.
Lordship, my prayer is not conflicting because I am praying for prosecution sanction to be accorded, Lordship.
So-
Then also, this is not in conflicting with what they have, they're praying for, Lordship, because I was also informed that the respondents, some of the respondents were challenging the inquiry commission, Lordship, which was dismissed. So it is not in my knowledge the civil revision petition was filed, Lordship. However, this does not bar the petitioners from approaching this honorable court, praying for adequate reliefs,
So
Lordship.
you have impleaded whom then?
I have completed all of them, Lordship, the concerned respondents.
The state also?
The state also, Lordship, including the Director General of Police, Lordship, and also the Superintendent of Police, PEC.
Prosecution sanction against officers will be
Erring
issued by the
officers,
central government
Lordship.
only.
Yes,
Mm.
it will be by the central government. Yes, they are absolutely right, because in challenging the proceedings also, if they have already been registered, because without prosecution sanction, they cannot proceed. So that's why the petitioners are here before this court, Lordship, because this court has the jurisdiction, as so is this Honorable Apex Court has also stated.
Okay, fine. Issue notice. Calling upon the respondent. And issue rule. Huh? Calling upon the respondent to show cause as to why, and issue notice, huh? To show cause as to why a rule should not be issued is prayed for. And or why. Other orders or directions shall not be issued as this court may deem fit and proper. Stop. Huh? The notice is made returnable by 4 weeks. Since Mr. Court's name, huh? So has accepted notice on behalf of respondent number 1, 2, 5, 6, and 8, and Mr. So on behalf of respondent number 3, 4, and 7. No separate notice need be issued to the said respondents. However, the petitioner self furnish requisite extra copies to the said respondents within two days.
2 days,
Within
Lordship.
2 days. Stop. List is para. List is there any other, so you are representing all the respondents?
So all
No other
respondents are
respondent.
represented. All respondents are
Okay.
represented.
Okay. List is matter after 4 weeks.
Lordship, after?
4 weeks. So in the meantime, you file affidavit?
Well,
okay.
What's the question?
Obliged, Your Lordship.
For motion, item number 56.
May I please, Your Lordship?
Yeah.
Your Lordship, here the petitioner is praying for bail during the pendency of the case, Lordship. The petitioner is praying for bail during the pendency of the case.
Petitioner?
Is praying for bail. This is a bail application.
Bail application.
Yes, yes. Your Lordship, here on 26/2022, NFR was lodged before the Women Police Station, Kifri. Accordingly, in connection to the incident, FR, one alleged accused person was arrested.
This
Now-
was in the June 2023.
Yes, Lordship.
He was arrested.
Yes, Lordship.
Okay.
Basing on the FIR, the alleged accused person was
Probably
arrested.
charge sheet already filed
Yes,
by
Lordship.
now.
Yes.
Trial already begun.
Not yet, Lordship, not yet.
Not yet.
Yes.
Okay. So charge sheet was filed on time?
Charge
within
sheet
the
was-
thi- Within the statutory period?
Yes, Lordship.
Okay, so you moved the bail application before the trial court?
Yes, Lordship.
It was rejected?
Yes, Lordship.
When last it was rejected?
Your Lordship, my subsequent bail application was rejected on 15/2/2024. That is in,
24.
yes,
February.
yes, that is in Annexure 3, page 13, Lordship.
It was rejected on merit?
Yes, Lordship, it was rejected.
Rejected on merit? After hearing the parties?
Yes, Lordship.
Okay, what is the new ground that you have taken this time?
Lordship, the petitioner has already been spent for more than 282 days in the judicial custody. Now, my second ground is that, as per the medical report of both the victim as well as the accused person, it is very much clear that there is no such kind of as alleged in the FIR.
Were the charge framed?
Not yet, Lordship, not yet.
Charge not yet framed?
Yes, Lordship.
So make an argument at the time of framing charge for discharge, if you think that you are innocent. Okay, yes. So since case has already been charge sheeted, can call for a scan copy?
Yes.
Or what? You want to obtain instruction? Scan copy, I think.
Yes, Lordship. Otherwise, even in
But-
charge sheet, there's clear proposi case against.
Yeah, that is why. So your bail has already been rejected. I think more than once. You have made a subsequent bail application also, that also rejected on
Yes.
merit. So no new ground as such.
Your Lordship, Your Lordship may kindly see my para number 10, Lordship.
What is there?
Your Lordship, the alleged accused person has been suffering from chronic liver disease, which the medical doctor has also prescribed for further medical checkup, Lordship.
That the jail authority will take care of. But will direct. Okay. Mr. Osman Pongner, huh? Learning counsel for the petitioner. Also heard Mr. Ngami, learned PP, public prosecutor, no? Okay. Government of Nagaland staff. Para. This is an application under section 439 CRPC. Praying for release of accused Aziz Pathan, alias Pathan Aziz, R number 5019427, who has been arrested by the Kipire Women Police in connection with the Kipire Women PS case number 3762, within bracket 2, within bracket C, bracket close, within bracket L, bracket close, within bracket 3, bracket close, IPC, read with 6/10 POCSO Act. In correspondence with GR number 21/2023, stop. Issue notice, call for the scanned copy of the case record. Since Mr. Laratipiha accepted notice on behalf of the respondent.
Lordship, respondent number 2.
Respondent number 2.
Respondent number 1, victims for this.
No formal notice need be issued to the state respondent. However, stop. Sir, just a minute. So far as the respondent number 2 is concerned, comma, the petitioner shall take. No, respondent number, he is 2, huh? So now, so far as the respondent number 1 is concerned, the petitioner shall take steps by a registered post with AD within 4 days from today. Start. List this matter after 3 weeks.
Lordship, after
2 weeks. Okay, then you take steps within 2 days.
Okay, Lordship.
Okay. Then after 2 weeks, list this matter after 2 weeks. Okay.
Much obliged.
For orders, item number 24.
May I please, Your Lordship?
Yes.
Lordship, this honorable court by order dated 2/4/2024 directed the appellant company to take steps upon respondent number 2 and 3.
Have you taken?
This morning only I have taken steps, Your Lordship.
Okay. Mr. You are Mr.
I'm appearing on behalf of Sir Vikramjit Devnath.
Vikramjit Dev. Okay, you are Mr.
Dinagi.
Appearing on behalf of Mr. Vikramjit Devnath, Land Counsel for the petitioner. Submit said he has taken steps upon the respondent. Respondent number?
2 and 3, Your Lordship.
2 and 3, today itself. How many respondents are there? So what about the other respondents?
One is appearing, respondent number 1 is appearing, but respondent 2 and 3, last time we have served notice, but it came answered.
So respondent number 1 earlier appeared?
Yes, Lordship.
Okay. No one appears on behalf of the respondent number 1. Stop. In view of the above submission, list this matter after 2 weeks. Where is the address of the respondent? How long it will take? After 2 weeks or 3 weeks? Just tell.
Lordship, 3 weeks time may be granted.
3 weeks?
Yes, Lordship.
Okay, after 3 weeks. Okay.
Much obliged, Your Lordship.
For orders, item number 27.
Yes.
May it please your lordship?
Yes.
Your lordship, in the previous occasion, I served a copy to the respondent 2 and service has been completed on 4/4/2024.
Respondent 2 was issued. Still awaited?
No, lordship, it's completed. I checked
Complete.
today, yes.
Notice upon the respondent number 2 was issued on 12. So just a minute. 2/4. What is the updated service report? Upon how many respondents are there?
The state and the complainant, 2 respondents, lordship.
Okay, so then, but in the last order, by last order,
Yes, lordship,
It says-
it's in the office note, lordship.
in the office notes, pay concernment indicates delivery confirm. Okay, this was on 2/4. On the same day it appears. Okay. Miss.
Lordship, so on 11/3/2024, this court had noted that my prayer for stay will be considered after service of notice to respondent 2. So if my prayer can be heard today, lordship.
Miss. You are Miss?
Obang Nanlalong Char, lordship.
Okay. Land Counsel for the petitioner. Stop. Also had Mr. Your age here,
Lordship, appearing
common
on behalf,
advocate.
appearing on behalf of my colleague, Miss MS Mere.
Okay.
She has different person.
Appearing on behalf of Ms. Mary. Lara Council, sorry, appearing for the state respondent. Start. Para the office note dated 2/4/2024 reflect that the delivery of the notice upon the respondent number 2 is confirmed in view of the above. The notice upon the respondent number 2 is complete. Stop. No one appears on behalf of the respondent number 1. Who? Sorry, not 1. 2 is appearing, and who is other respondent? For the other respondent?
Your Lordship,
Total, how many respondents you said?
only 2 respondents,
Only 2.
including the state.
Okay. What is your grievance, this?
Your Lordship, our discharge order has been rejected by the JMFC. Our discharge, the discharge application before the JMFC was rejected.
What discharge application?
Lordship.
Rejected?
Yes, Lordship.
Then?
Your Lordship, it's at page
So
1.
discharge application, if rejected, means charge framed.
Yes, Lordship.
So what?
Charge has been
So then,
framed, Lordship.
charge framed against you.
Yes, Lordship.
Under what? Under section?
Your Lordship, under
Have you
section
annexed?
420, Lordship, the cognizance order is also there, and as well as the charge, Lordship. The charge is at page 54,
54.
Lordship. Your Lordship, there are about 14 accused persons here, and we are appearing. We are for B5.
How many total? How many accused? 14.
14, but we are only for one of the accused persons.
You are for accused number?
B5, Lordship.
Accused that he is accused number?
B5.
B5,
Lordship. Your Lordship
is Samuel Gopal, Osito, Lima
Angla, Lordship.
You are for Lima Angla?
Yes, Lordship.
13.
Yes, Lordship. 13. Lordship, the charge
So,
is.
but then you see the charge framed against all these 14.
Lordship.
So this charge was framed on which date?
It was framed on 2nd December 2021, Lordship.
Then there was no stay was granted.
No, Lordship. After filing this,
evidence must have recorded by now.
Your Lordship,
2-3 times.
Lordship, we have not completed CC also before the JMFC.
Hmm?
We have not completed CC, consideration of charge before the.
No, this is you see charge frame.
This is only the charge sheet, Lordship. And before CC, we applied for discharge.
Just a minute, just a minute. You say this is. Okay. This is charge sheet.
Lordship.
For offense 420.
420, 120B.
So in the court, charge not yet framed.
Lordship. The cognizance was taken and then consideration of charge is yet to be taken.
So you faced the trial.
Lordship, we have applied for discharge, but then since it was rejected, we are coming.
No, discharge prayer you can make at a time of framing charge.
Lordship.
There only you just show that you are innocent. There is no involvement.
Lordship,
if nothing fine against you, then charge will not be framed against you.
Lordship.
But then unless the charge is framed, and hearing taken place for framing of charge, then how do we know that? Because there is material against you. Prima facie, there is a material against you as per the charge sheet.
Lordship.
Make an argument before the trial court at the time of framing charge for discharge. Then, despite of that you are innocent, or there, despite of having no any evidence against you, no prima facie or no any incriminating material against you, if the court frame charge against you, then only you can come. These are the, there is nothing against you, but then despite the charge has been framed, then you can come. But then at the moment it's too early.
Lordship.
You make argument before the trial court that there is nothing against you, because there are 14 out of 14. It is possible that you may be innocent. There may be no any material against you. You make an argument before the trial court for discharge on the day on the at the day of framing of charge, hearing on the framing of charge. Okay.
Lordship.
So but this is too early. Before hearing on the framing of charge, stay would be difficult. Huh? So what do we do?
Your Lordship, until this case is disposed of before this honorable court, Lordship, I pray that
Dispose of will be a dismissal.
Lordship, either way, Lordship, until the final hearing, if the lower court proceedings can be stayed, Lordship.
No, that cannot be, because there are other accused persons also.
Lordship.
Had it been your case alone, and then if you pray, and then on perusal of the records, if there is nothing, then of course we can go ahead with the stay also, and then for hearing.
Lordship.
But then under the facts and circumstances of the case, when there is a prima facie case against you, incriminating material reveals, and then IO also says that there is a material again found against you, then we cannot just stay, cannot intervene.
Lordship. Then, Lordship, it may be disposed of so that we could continue with the lower court proceedings, Lordship.
Yes, that will be better, huh? So respondent number 2 is informant. Informant is also not appearing, huh?
Yes, Lordship.
Just let us see once what is the have you annexed the FIR also?
Yes, Lordship. It's annexure 1
Since
page.
it is in the overall column, I did not see the detail.
Page 14, Lordship.
14. No, content of the FIR. This is.
Lordship, we do not have that sheet. They have attached a separate
Okay,
sheet.
so then we'll have to go to the charge sheet. There is allegation against you. maybe it will be difficult for you. Better withdraw and come again after. If you think that you have a case after framing of charge,
Lordship.
better withdraw now. Come again after withdraw. In any case, the respondent is also not appearing,
Yes.
and this is the SIT case. Forgery, and there is a material. Make a prayer there. Prepare for the argument before the trial court. Okay.
Lordship.
So withdraw.
Lordship.
Okay.
Lordship, with liberty to approach.
Yes, definitely. Okay, Miss
Ubang nanlalong charge.
Learned Counsel for the petitioner submits that so you do not know when the next date is fixed for CC.
Your Lordship, it's fixed on 6th May.
6th May, okay. After submission of charge sheet, after taking cognizance of the case, the above the case
GR 80. 80 of 16.
Or 16 is fixed for hearing on consideration of charge on 6th May. And since the case has already been fixed for hearing on the consideration of charge, she wants to withdraw this petition with liberty to file again if so advised. Since fixed for hearing on charge, she would like to make a prayer before the trial court for discharge of the accused applicant. Stop. Okay. Now that will come. And in the meantime, she wants to withdraw this petition with liberty to file again if so advised. Stop. This petition is dismissed on being withdrawn with liberty is prayed for. Stop. Mr. Jimomi is present. Dana PP is present. That will be better.
Obliged, Lordship.
For orders, item number 28.
Yes.
May I please, Lord?
Yes.
My Lord, this matter is arising out of a land dispute between two villages. And there has been checkered history of litigation in connection with that land dispute. And all along, the matter has been decided in favor of the present petitioner. But then, in order to dilute the issue, they have filed a complaint under section 200 CRPC before the Session Judge Moon. Now,
before 200? Before
section
Session Judge?
200 of CRPC, a complaint has been lodged.
Before Session Judge?
Yes.
Can be lodged?
Magistrate, sorry. Magistrate.
Yes.
Now, against that, the petitioners have filed an application under section 482 CRPC for quashing the criminal complaint. It so happened about 5, 6, 7 years back, when the Chief Justice Lamba was sitting, we moved the application. But then it was the opinion of the Honorable Chief Justice, then Chief Justice, that revision will lie under section 397 and 399 before the Session Judge. So you approached there. So since that was the expression and the order is also there, so we, in terms of the order passed by this Honorable Court, we approached the Session Judge under section 397 and 399. But ultimately, the Session Judge has dismissed that on the ground that under section 397 and 399, sitting judge do not have the power to exercise the power of revision. That is, I think, perfectly okay. So we are again coming under 482 for quashing the criminal complaint 2 of 2019 because it is purely a civil nature. The complaint do not disclose.
Criminal complaint saying what? What is the allegation in criminal?
Allegation is we have wrongly misinterpreted the order passed by the Additional Deputy Commissioner Judicial. Now it is the district judge, but earlier it was district judge was Additional Deputy Commissioner Judicial.
Have you annexed a copy of the?
Yes, I have annexed a copy of the complaint. Lordship may kindly see the operative portion.
Is
Lordship will find the complaint at page 91. Annexure N. And just to save time, Lordship, I will take the Lordship's attention to page 101. That is the sums and substance of the complaint.
Right.
Page 101,
Yes.
paragraph 7. May I read, Lordship?
Yes.
It is respectfully submitted that the accused respondent and their village, Todokchinyo, that is the present petitioner, should not be allowed to go scot-free for misinterpreting the judgment and order of this honorable court in an open and contempt of court. So their sole complaint is with regard to the misinterpretation of a court order.
Misinterpretation before?
They are saying that we have misinterpreted the court's order.
Where you have misinterpreted?
That is why. Where we have misinterpreted. They should disclose. If there is any misinterpretation, they should file a contempt of the court. Because it is a civil nature. If we have misinterpreted in a particular manner, which should not happen, then there is alternative remedy for them. And all along, all their complaints with regard to the civil nature, those has been dismissed. EAC has dismissed their complaint. They have filed an appeal before the Deputy Commissioner. That is also dismissed. And this honorable court has also dismissed. So they are trying to create a fresh controversy by filing this complaint. That is why we are before this honorable court for quashing the criminal complaint. Now, as per the last order.
This is the complaint?
Yes.
Against which?
Against the Todokchinyo village.
Okay, and you have filed against this complaint. Whether this complaint has been taken cognizance of?
Yes. That is why we are before this honorable court, Lordship.
You have annexed that order?
Order. Yes.
By which the learned magistrate has taken cognizance?
Indian order, Lordship will find at page.
That must be the impugn order?
Yes. Impugn order is at page, no, magistrate order. 102, Lordship.
One zero?
102.
Two.
Yes.
Okay. No, this.
104. No? Up to this, page 104 is the summons. Against this, we have approached this honorable court on the earlier occasion. And the Honorable Chief Justice was of the opinion that no, against this revision under section 397 and 399 will lie before the session judge. So you go and approach there. So we approached there and then that was dismissed. So we are again coming, challenging the same criminal complaint, Lordship, for question. And as I have referred to your Lordship, the complaint itself do not disclose the commission of any criminal offense. It is with regard to the interpretation of the court's order. And Lordship, as per the last order, passed by this honorable court, the interim is to be considered today. Because on the last occasion, the notice was not completed. Notice was issued to the respondent, and office note indicates that the notice has already been effected to respondent number 2. And today is fixed for consideration of the interim. So my only prayer is to suspend the proceeding of complaint case 2 of 2019.
So how many
report may be called
respondents, state and the private respondent?
Yes, private
Whether
respondent is one
private
village.
Respondent appears?
Opponent village. They have not appeared so far.
Okay, but
Notice have been completed. Office note indicates that, Lordship.
Okay.
It is purely a civil nature with regard to the interpretation of the order passed by this honorable court and the additional deputy commissioner judicial.
Record was called for? No.
No, not yet, Lordship.
Not yet.
Yes. Records may be called for, Lordship.
Okay, you anything?
No,
Okay.
Lordship, I have intimate to the respondent, Lordship. but
Okay,
if there's
yes.
no instruction-
Mr. Citizen Zamir, Senior Counsel, assisted by
Ms.
Income.
T. Sakru.
Sorry.
K. Sakru. K. Sakru.
Senior Counsel for the petitioner. Petitioner is 1 or 2? How many petitioners?
1.
Only
Two, Lordship.
petitioners.
Yes.
Okay, stop. Also had Mr. V. Zimomi, learned public educator, representing the state of Nagaland. Stop. Para. Office note dated 2/4/2024 reflect that a notice upon the respondent number 2 has been delivered and confirmed. In view of the above, the notice upon the respondent number 2 is treated to have been completed. Stop. However, no one appears on behalf of the respondent number 2. Stop. Para. Call for. We'll call for the scan copy only. It's very difficult sometime in the trial court. If you send the entire document, it's difficult. We'll call for the scan copy.
Lordship, once the proceeding is suspended, it will be of no use for them also.
Okay, call for the record.
Record of criminal case, complaint case number 2 of 2019
Of
in the court of
record,
CJ Moon.
Complaint case number
2 of 2019.
2 of 2019. Before the 2 of 2019. Huh? Pending before the Learned Court of Chief Judicial Magistrate, Mon, Nagaland. Stop. List this matter after 4 weeks. Stop. Para. In the meantime, where is your interim prayer?
Page 24, Lord. From the top.
Okay. Upon hearing the parties and and having regards to upon consideration of the contention made in the petition and having regards to the submission made by the learned counsel for the petition, it is provided that in the meantime, as an interim, in the meantime, the proceeding of the above case number, that case, right, to number 2 of 2019, before the court of the Chief Judicial Magistrate, Mon, Nagaland, shall remain.
And the summons dated 18/6/2019.
Summon dated also?
Yes.
And the summon dated
18/6/2019.
6/2019 shall remain stayed. Till returnable date will say. Okay.
Much obliged.
For orders, item number 29.
Your Lordship, service upon respondent 9 is still awaited.
Yes.
Kindly grant us 3 weeks' time for completion of service.
Okay. Miss,
And solo.
counsel for the petitioner. He is present. You are for?
Your Lordship, I'm for the respondent number 1, 2, and 3, Your Lordship.
Okay.
The name of the leading
Mr.
counsel may
Mr.
kindly be reflected,
Mr.
Mr. Singh, Your Lordship.
Is also present for Mr. counsel for the respondent number
1, 2, and 3, Your
1,
Lordship.
2, and 3. And Mr. Jimomi, Lanaka. Okay. You are for state respondent. Okay. Are also present staff. The office note dated 9/4/2024 reflect that the service of notice upon the respondent number 9 is still awaited. So what about the other respondent?
Your Lordship, they're all present here.
All, okay.
Yes.
Okay, state and vote, okay. So in view of the above, list this matter after 3 weeks.
Yes, Your Lordship.
Okay.
Yes.
For orders, item number 30.
Your Lordship, similar prayer in this matter as well.
So here also
Yes, service upon respondent 9 is still awaited.
9.
Yes, Your Lordship.
Okay. This is a similar case.
Yes, it's
Same,
regarding
same.
the same, yes, Your Lordship.
Same. Okay.
Much love.
For unlisted motion anticipatory bail 6/24.
May I please, Your Lordship?
Yes.
For the application, my lord. FIR starts from page 9, my lord. My lord, religion, portion page 10.
Yes.
One brief of the fact that FIR is that, as per the allegation, a certain sum of money was alleged to be given to me for procuring petrol pump license. For
Procuring?
Petrol pump license, petrol pump.
Okay.
Now what happened was that, my lord, in the year 2018, there is an advertisement that, Your Lordship, you will find it in page 13. Page 13.
Yes.
Now, as per this advertisement, Indian Oil Corporation was supposed to give license for opening retail outlet in various places of Nagaland. Now, my wife, the petitioner's wife, happens to belong from the Siwan district of the Nagaland. And so I had many persons, means her family members and many persons who are known to him. So, my lord, what happens is some person approached the petitioner and said that I am required to do the needful for obtaining for them a petrol pump license.
For whom?
One person by the name M. Imdong Chang. So later on, means actually, my lord, actually is this type of arrangement actually.
Just a minute. Let us see the FIR.
Yes, ma'am. I will come to the FIR. I will come to the FIR.
Okay.
So just I'm giving the brief background.
Okay.
So first things start from the year 2018. Now
2018.
2018, the advertisement was issued. 2018.
Advertisement issued 2018.
Then, my lord, the draw of lot was declared that your lordship will find it annexer 3 page.
What was declared?
It was by the person who was selected by way of law. And it was M. Inglong Chang, my lord. Page 14, your lordship may see. This was on 28 August 2021.
What is this?
My lord, this draw of laws, Indian Oil Corporation has informed M. Imdong Chang that he has been selected. But unfortunately, my lord, may I kindly see the death certificate. Page number 15.
Yes.
The said person, my lord, after applying for the said license in the year 2018, he expired on 29/1/2021. That means before the lot.
This lot was drawn in
the month of
August. August 21.
Yes, my lord.
Okay.
Because
he died on
in January. In the month of January.
Prior to the declaration.
Yes, my lord. That is
draw lot.
Yes, my lord.
Okay.
Now, my lord, because some arrangements is required to be made. So, my lord, expenses actually are incurred.
Arrangement means what arrangement?
Arrangement actually this type of licensing, my lord. If I'm not mention it, it's type of licensing because of Indian Oil Corporation, my lord. They grant license, my lord. So this we have applied in the year 2018 and in the year, but unfortunately this person
2021 he died. And
so
in the same year after his death,
the draw was done and he was selected.
He was selected and nobody informed.
No, I'm coming now.
Okay.
So in the year 2000, now my lord, the persons from that locality are saying that the license should be transferred to the name of some other persons. This license, which he will get for opening the petrol pump, should be in the name of some other person. That means it should be changed. But as there is no provision, my lord, there is no provision, so I was
not even for the family members.
Not even for the family members. Suppose I have a driving license. This driving license cannot be transferred.
It's like a driving license.
It cannot be transferred to my son. So
yes.
Generally, what happens is that in most of the cases, people generally make a company, or a farm, and in this way they operate. So if a person dies, then new person is brought, and suppose there are many Saraugi, as your lordship is aware that Sanmal, Saraugi, petrol pump are operating in many parts of the state of Assam and even in Nagaland, to my knowledge. So what they make is that they make a company. So in the name of company, this license is given, and after if the director dies, then they immediately make a board meeting, and another new managing director takes his place. So now, my lord, here in this case was that it was given in the name of an individual person. It was given in the name of an individual person.
Yes.
But as per the FIR, now, my lord, now I'm going to take your lordship to page 10, my lord. Page 10.
Yes.
Para number 4, your lordship may kindly see. Para number
just a 4. Just a minute.
Yes, your lordship may see that.
Who made this FIR?
This lady is a person from the same district.
Same district,
but
how he is connected with the deceased?
No, deceased means
is she connected with the deceased?
No, they had a friendly relation with them because they were supposed to operate the petrol pump jointly.
Okay, the person who died and this.
Yes, they were supposed to operate the petrol pump in a joint manner. Maybe they all would have a share. They would all have a share in the said petrol pump.
Okay.
But now, my lord, if your lordship see page number, paragraph number 4, 7
let,
lakhs.
let us see,
Ah, yes, yes.
what is this para number? Let us start from
Yes, yes,
para
the
number
founder
one.
member. I, Lordship, my lord.
Yes, madam. Yes, para four.
Therefore, I just want to see, my lord, the money that was given, 7 lakhs, in the year 2018. That means after the advertisement was issued, my lord. So, and my lord, and they have also stated one thing that
7 lakhs were given to whom?
my lord, they have
Amount of 7 lakhs was given to
Kali
whom?
Rock Infrastructure and Creation Private Limited.
Kali Rock.
It directly did not say that to the petitioner, but here Kali Rock Infrastructure, they, according to them, this organization is related to me. So all these bank transactions were done with the said farm. And here in page number 11, that I'm reading that Mr. Raju Chandra said that since the petrol pump contract is delayed for a long period of time, on which himself offered another project known as CSR project amounting to this 3 crore. He asked 33 lakhs as 1% of the said 3 crore with the promise of sooner delivery. The project we introduced with the promise is never delivered till date. Problem actually arose because of the death of the person. Yes. Even then, my lord, the petitioner now, my lord, he informed me that he is willing to return this 3 lakhs rupees, which he obtained later on. And so, my lord, if your lordship giving opportunity to him to approach the police station and record his statement and with some interim protection.
So this was, FIR was closed on March.
Yes, madam. Yes, March 27.
The last payment was made in the month of?
Madam, in the year 2021, August 2021, 27/8/2021.
The case was registered,
Under section 420, my lord, page 12, my lord.
We'll call for police to notice.
My lord, only one thing.
So, call for the city.
Yes, ma'am. Well, only I'm giving interim protection. I will go to the police station to record my statement, my lord. I'll go to the police station, my lord. If any material is there against me, your lordship may reject my bail application.
Or Mr.
I Chaudhary, my lord.
I Chaudhary, learned counsel for the petitioner. Also Mr. Gami, learned counsel for learned PP, Government Nagaland. Staff. This is, sorry, just a minute. Apprehending his arrest. In connection with Tuansang Police Station case number 16, 2024, under section, registered under section 420 IPC, the applicant filed this bail application under section 438 of Code of Criminal Procedure 1973, praying for grant of pre-arrest bail. Staff. Issue notice. So have you made party to the informant?
No, my lord, only in case of POCSO case. it
No,
is
no,
required to
no,
be
I'm
made
just
petition.
asking.
Oh, no, my lord.
No, only state. Okay. Okay. Returnable by 3 weeks. Tuansang, how fast? 3 weeks is okay. Yes. Okay. Since Mr. Angami accepted notice on behalf of the state respondent, no formal notice need be issued. Start. List this matter. No, call for the issue notice after that. Call for the scan copy of, since it is on scan copy, we'll say scan copy of the case diary. Start. And thereafter that. Then list this matter after 3 weeks. Start. In the meantime, as an interim order, it is hereby provided that no, there is in the event of that till the returnable date, in the event of the accused applicant being arrested in connection with the Tuansang Police Station case number 16, 2024, under section 420 IPC, he shall be released on execution of a bail bond of rupees 1 lakh with 2 surety of like amount to the satisfaction of the IO of the case, with the further condition that the accused applicant shall appear before the shall cooperate the IO and appear before him as and when called for. Where this accused person stays? Where?
Gauhati.
Okay, Gauhati. Okay. That the accused shall not applicant that he shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such fact to the court or to any police officer or tamper with the evidence. Any other condition?
If he may be directed to personally appear before the.
I'll appear. I'll appear.
If he may be directed to on a specific date, because if someone issued, then if he comes up with some excuse, I didn't receive.
If he doesn't appear,
yes.
If he doesn't appear, it will be cancelled only.
Yes, yes.
But
if he appear only, he will be arrested. Unless he appear, he will not be arrested.
I understand that. And my Lord has also said that as and when he's someone called for. But if a specific date may be indicated in the order, so that.
Now that will confirm that he will appear and then he will be released only.
Okay.
So, okay. Then the first condition will be that the accused shall appear before the eye of the case within 10 days from today.
Yes, ma'am. Yes, ma'am.
Within 10 days.
Yes, ma'am.
From today. Okay, then the others. Yes. In the last. Okay, it is till returnable date only. No problem.
One is there actually.
Yeah.
If 3 weeks actually, it will be difficult for me to know on which date it will be listed. I'm coming from what. So if a specific date is given.
Okay, then list this matter on
7.
6 or 7. 7. Okay.
Of Lordship. For hearing item number 38.
Yangabati, who appears for the other side?
No one has appeared so far.
Then it will be difficult.
Yes, we have published in the paper also on 2 occasions.
What to do then?
But till date, none has appeared. So let's just given Lordship.
Okay.
Because as per the contract agreement, the parties, they have a right to appoint a sole arbiter from the office of the Ministry of Law. But anyway.
Sole arbiters already appointed?
No.
Or not yet?
Not yet. Because since none is appearing.
Okay.
As a last chance, Lordship.
Okay. Mr. Yangabati, Learned Counsel for the petitioner is present. No one appears on behalf of the respondent.
In spite of the substitute notice, Lordship. Yes, notice was published in the paper also at their residence at Mumbai, Maharashtra.
Okay, despite of no one appears on behalf of the respondent, despite of a notice being published in the newspaper.
Well, look.
Stop. However, for the end of justice, one more chance is given to the respondent for his appearance. No?
Yes.
List his matter after 4 weeks.
Well, 2 weeks, Lordship.
Maharashtra?
Maharashtra, yes.
I think 4 weeks.
Okay. Much obliged.
For hearing item number 39.
Yes.
May I proceed, Your Lordship?
Yes.
Lordship, by this revision petition, I'm challenging the impugned decision of the Dubashi.
Let us ensure all the parties are present.
Yes, Your Lordship, government. is
Represented?
Yes, my colleague is outside, but he's.
Okay.
Sativa is coming.
Okay, just a minute. How many respondent parties are there?
Lordship, 4 respondents. 1, 2, 3 is represented by government, and there's a
Lordship,
private respondent also.
I'm for respondent number 4.
You are 4.
Yes, Your Lordship.
You are 4. Just a minute. Okay, 1, 2, and 3 are by the government advocate, and you are for respondent 4. Okay, then it's fine. So, yes, what is this matter about?
Lordship, I'm challenging.
This is criminal revision.
Yes, this is a revision petition, and I'm challenging the impugned decision of a Dubashi court. Dubashi court, Chief Pobozu Kohima. Lordship, solely on
Against
the
Dubasi, decision of the Dubasi court criminal revision lies before the High Court.
Lordship, because I'm challenging on the ground that the Dubashi has adjudicated the matter and appeal without jurisdiction.
Okay.
Yeah, that's my primary point. Lordship. Yes. Firstly, the factual background, if I may, Lordship. The present issue is a land dispute, and it has arisen out of a partition of an ancestral property at Tepcheba, which is under Nerhema village, under Kohima district, Lordship. And Lordship will find in Annexure 3 that an agreement has been executed. Annexure 3, page 29.
Please.
The translated copy is in page 30, Lordship.
Just a minute. You are also. So the respondent is that means your brother?
He is a relative, Lordship.
Relative?
Yes.
Okay.
So,
okay, page?
Page 30, translated copy is in page 30
page
of the petition, yes.
So what is this?
Lordship, this is in regard to the partition of the ancestral property. An agreement to that effect has been executed. And this is the agreement, Lordship.
Agreement between?
Between the family of the petitioner and the family members of the private respondent.
Private respondent also?
Yes.
So that is their family member. The private respondent is also members of the family?
Yes. And both of them are signatory to the agreement.
Okay.
The petitioner as well as the private respondent.
Okay.
Yes.
Let us see.
May I read, Lordship?
Yes.
On this day, the clan property at Tepcheba has been divided. Lordship, the date is given as 29/11/2002. However, inadvertently in the original agreement, yes. The lower portion area of the landed property shall be given to Nisitio and Bhalel Hulia. Nisitio is the private respondent, Lordship. So a portion has been given to private respondent and another person. it is decided that the upper portion area of the landed property between the Bawe Road till the road leading to the Bangalore shall be given to Nizelhu. This was agreed unanimously by the family with regard to Lutyo. It has been decided that since he had sold a plot of land at Sassake, no property at Tepheba shall be given to him, and signature has put to that effect. And in order to avoid any dispute, the elders in the clan has appended their signatures. And accordingly, Lordship, some of the elders also appended their signature to the agreement. Lordship, here, the name Nizelhu, where the upper portion has been given to him, is the father of the present petitioner. Lordship, in the second para, it has been stated Nizelhu.
That means the lower portion area of the landed property shall be given to the
Nizitu and
Nizitu is the respondent number 4.
Respondent number 4. And in the second para, it is decided that the upper portion area of the landed property between the Bawe Road till the road leading to the Bangalore shall be given to Nizelhu, who is my father.
Is father of
petitioner.
Okay.
And Lordship, as stated in the agreement, some of the elders also appended their signature.
And who is this Lotho?
Lutyo, he is also a relative, but he is not a party.
Is not here, not with us.
He is not a party before this court because
okay.
there is no dispute
with
Lutyo, neither with Halil Hulye.
Okay.
Yes. And after execution of this agreement, and Lordship, before going any further, Lordship will find that there is no condition. There is no condition to the agreement. It's just that the upper portion and the lower portion has been divided between the two parties. That's all. Thereafter, on 29/2019, in violation of this agreement, the private respondent started encroaching and excavating the land of the present petitioner.
Nijidu.
The present petitioner is Nizelhu's son. Nizelhu is no more. And at that relevant point of time, the present petitioner was away from home. And therefore, when his wife confronted the encroachment.
But he is the only son of Nejolu.
Lordship, there is no dispute in as far as
in his family.
Yes.
Okay.
This portion
is the petitioner inherit
him by his father.
Okay. Petitioner inherits.
Inherit.
Okay.
However, this is in customary style, so therefore there is no document to that effect, Lordship.
Okay.
Yes.
So the father is now no more.
Father is no more.
Okay.
Lordship, on this very day, when the private respondent started encroaching, since the petitioner was not there, petitioner's wife confronted, and she was physically assaulted by the private respondent, and therefore, a complaint case has been filed before the Nirhema Village Council by the present petitioner. And this, Your Lordship will find in Annexure 2, page 27. The typed copy is in page 28, translated copy.
Yes.
Married Lordship.
Yes, please.
To Judicial Secretary, Nirhema Village. Subject, land dispute issue between Nisitio and Nodele. Nodele is his wife, petitioner's wife. Sir, respected Chairman, Secretary, Head GB and GB and members of the elders of the village. Firstly, I'm grateful to you all On 29/2019, while I was traveling, Nisitio and his brothers dug up my portion of land with JCB on the already divided partitioned family property located at Tepheba. When my wife Nodele had raised objection, Nisitio had physically assaulted her. Therefore, the council is requested to intervene in the case at the earliest. And Lordship, upon this, the village council Nirhima had passed a judgment in order. Lordship will find the translated copy in page 26.
Just a minute.
Lordship.
This complaint was lodged, no?
Complaint was lodged.
On which date?
Complaint was lodged on
Date not given.
no, dated nil, Lordship.
This judicial secretary means what?
Judicial secretary.
The complaint was made to the judicial secretary.
He is one of the member of the village council.
Okay.
From amongst the village council members, a judicial secretary has been normally elected by the village council, Lordship.
Okay.
Yes, that's the normal practice.
Yes.
So upon giving that complaint, the village council has adjudicated the matter. This Lordship will find in Annexure 1A, page 24, the judgment of the village council. Yes, and the translated copy is in page 26.
This was decided on
9/10/2019.
This we call it decision of
the village council Nirhima.
Okay. Yes.
May I read the decision, Lordship? Case number. So, case number blank. On 9/10/2019, the Nirhima Village Council had recorded the statements from both the parties and all the witnesses pertaining to the issue that has arisen between Srimati Nodele Resu and Sri Nisitio Merheso on 28/2019 and passed the following judgment. 1. It has been established that the deposition of the witnesses that on 29/2019, Nisitio has raised his hands on his aunt Nodele by pulling her and made derogatory comments against her mother, Jinyo. Therefore, he shall apologize for that. 2. Both the statements made by Nodele and Nisitio, wherein Nodele stated that the impending tragedy that would befall the Merheso family and the response of Nisitio on the said statement saying that should any loss of life occasioned in the Merheso family, no delay will be held responsible. It is directed that both of them should forgive one another and further ordered that both parties should refrain from bringing up the same issue in the future. In the event where any of the party raised the issue shall be liable to pay a fine of rupees 10,000 and the fine shall be paid to the council. Number 3, since there is a record of partition of the family property located at Tepriaba on 29/11/2002, the earlier agreement, Lordship, whereby both the parties had appended their signatures to that effect, as had agreed upon, the same shall be binding upon the parties. Which means it has been decided in favor of the petitioner, Lordship. Number 4, Lordship. While deciding the instant case, the issue of Ersu and Merheso was also raised. It is decided that henceforth the parties collectively should use Merheso as their surname. Lordship, I was aggrieved by point number 4. Point number 4 was not an issue before the village council. It was only the land dispute. However, the village council has decided in such a manner that, and before that, Lordship, my last name is Ersu, and the private respondent's last name is Merheso. Although they both of them are descendants of Ersu, some members of Nirhama village use Merheso as their surname or the last name. However, Ersu and Merheso, they are from the same line of descendants. So the village council Nirhama has decided on an issue which was not raised before them. The dispute was a land dispute, and therefore aggrieved by the very point of number 4.
So this number 4 is Ersu is a title.
Ersu is a title, and it is the legitimate name of my forefather.
And the another one is
Merheso.
Merheso.
Merheso, yes.
This is also another title.
This is also a title.
They are descendant of the same.
The same forefather.
Same forefather.
Yes.
Raise. It is decided that henceforth the parties collectively should use as okay.
But through this decision, now I'm forced to use Merheso.
So the petitioner is also what
petitioner is Ersu.
Ersu. So now the petitioner has also been decided to write his name as Ersu.
Yes,
sorry, not Ersu, Merizo.
Lordship. Arbitrarily, I was directed to use.
You are not agreed by point number 1, 2, and 3.
Yes, because point number 1, particularly point number 3, I went to village council because of point number 3, the land dispute. And it has been decided as per the agreement of 2002.
Okay, so
that is in my favor.
In your favor.
It is in my favor.
Okay.
However, in point number 4, Lordship, as I'm repeatedly advancing, Ersu is the legitimate name of my forefather, and in all my official documents, I've been using Ersu as my surname. And this has been used, this title or surname has been used by generations together in Nirhima village also. However, the reason why Merheso has been this issue has been cropped up is that, Lordship, on the fateful day when the private respondents started encroaching the petitioner's land, the private respondents on a verbally told the petitioner that petitioner's wife that unless they use Merheso, the ancestral property will not be given to them. However, during the time of partition also, there was no such dispute or
Use of, with regards to the use of title.
or condition, yes,
Okay.
Lordship.
This is extra additional condition.
Lordship,
Okay.
arbitrarily decided.
Although on merit, the property, particularly for which the this, what do you call? This is double
It was decided in favor of the petitioner.
Decision made by Dabasi.
By the village council.
This is village council, not the Basi.
This is village council's decision.
Okay.
So aggrieved by this decision, I have preferred an appeal before the ADC.
Okay. Yes.
Your Lordship is aware that under rules for administration of justice and police, page 34, rule 31.
Yes.
Married Lordship.
Yes, please.
An appeal shall lie from the decision of the Mozadar, Gambura, Chief, Headman of Khels, Dobashis, or other duly recognized village authority to the tribal court whenever constituted or otherwise to the deputy commissioner or his assistant. A record shall be made of the matter in the dispute of the decision of the village authorities. If necessary, the court shall examine the parties, and if the decision appears to be just, shall affirm and enforce it as one of its own. If the court sees reason to doubt the justice of the decision, it will try the case de novo or refer it to Panchayat as above. Lordship, therefore, as per the rules, I have preferred an appeal in Annexure 4, page 31.
Yes.
This appeal was preferred before Additional Deputy Commissioner Chepobozu Town Subdivision, Kohima, Nagaland. He is one of the assistants to DC. So under Rule 31, he is the competent authority to take up the appeal, Lordship. Marry the.
Okay, please. So this was by. So
this was by the by the petitioner, present petitioner.
By the petitioner, yes.
To the Additional Deputy Commissioner, Chepobozu Town Subdivision, Kohima, Nagaland, subject an appeal to the decision rendered by the Village Council, Nerhema, dated 9/10/2019. Sir, in inviting reference to the subject, I, the undersigned, beg to state that I had instituted a case before the Nerhema Village Council, Kohima, against Sri Nisityo, who had physically assaulted my wife and forcefully excavated and encroached upon my property land situated at Tepkeba, Nerhema village. Accordingly, on 9/10/2019, the Nerhema Village Council, Kohima, had rendered a decision basing on the statements record from both the parties as well as from the records, documentary evidences adduced before the council, wherein the issue pertaining to the title of the property land was rightly decided in my favor. However, the present appellant is assailing the same order judgment dated 9/10/2019 at paragraph number 4, whereby an obscure and irrelevant issue has been incorporated in as part of the judgment, that all the parties to the litigation were henceforth directed to use Merheso as their surname. It may be mentioned that my entire family has been using the surname Resu in all our official documents, which is the legitimate name of our forefather, and the usage of the surname has been passed on from generation to generation till the present day. Thus, the direction of the Nerhema Village Council at paragraph 4 is not only arbitrary, but unreasonable. As such, it is unsustainable in law. It is pertinent to mention that there were records of the opposite party using the surname Ersu in some official documents as well. Thus, considering the legitimate and widespread usage of the surname since time immemorial, it is not tenable in law to deprive an individual of his birthright and his precious dignity guaranteed by the Constitution of India. It may be brought to the notice of your esteemed office that in stark violation of the total disregard of the judgment and order of Nirhema, on 1/2/2021, Srinisitu and his family had trespassed. Again, they had trespassed my property, land, and forcefully felled 18 number of timber trees and took it away. Therefore, I beseech your esteemed authority to initiate appropriate action against the perpetrator for causing irreparable loss to me, despite being fully aware of the judgment of Nirhema Village Council, Kohima. Therefore, in the premises aforesaid, it is humbly prayed that particularly paragraph 4 of the order and judgment dated 9/10/2019 may be set aside and quashed and further passed such orders necessary as deemed fit and proper in the facts and circumstances of the case. Relevant documents enclosed. Yours faithfully, Lugevolia Ersu, son of Nizelhu Ersu, resident of Nirhema Village, Kohima, the petitioner. Thereafter, Lordship, the assistant to Deputy Commissioner, who is the ADC Chepobozu, instead of taking up the appeal, had again referred the matter to the DB's court.
Okay.
And the DB and the petitioner had started receiving summons from the DB's court. Lordship will find the summons in Annexure 5A, 5 and 5B, page 46, Lordship.
Forty?
46, Lordship.
Yes.
This is a summon from the DB's court, Chepobozu. And the case has been registered by the DB's court as Poll Case 1 of 2021, and the petitioner has been summoned in the appeal case. And in the next page also, Lordship will find that this is in the month of 15 April 2020. Dated, sorry, Lordship, 8 April 2021, the first summon. In the next page,
the 48 is someone issued to the respondent.
Page 46.
46 is
yes.
to Ersu only. Ersu. Who filed? Ersu versus okay, okay.
This is a
okay. No, this page 46. It is addressed to whom? The notice is?
To the present petitioner, Sri Lugevolia Ersu, Nirhema Village.
So, but then complaint was filed, appeal was filed by him only?
Yes. But instead of the ADC summoning both the parties for further proceedings, the DB's court, Chepobozu, has started issuing summon.
Okay, normally when you, because this is appeal,
Yes,
It has to be taken up by ADC only. And then someone could also not been issued by this DB, according to you.
Lordship, as per Rule 31, appeal can be made, can be preferred only to either the DC or his
ADC.
assistants and not to DBs. DBs has a concurrent jurisdiction with the village council.
Yes.
Therefore, the DBs cannot take appeal.
Yes.
They do not have the jurisdiction to
Is
do
it the
so.
case where the ADC has endorsed the DB? No.
No, still
But
no. Lordship.
only someone was issued
Yes,
by
Lordship.
the DB.
Lordship.
Yeah, DB. Okay. Then 47 is also.
47 also, another summon has been issued dated 11th May 2021.
So what happened in those in the earlier day?
He did not present himself before the DB's court.
Okay,
in the earlier question.
the petitioner.
The petitioner.
Okay. What about the other party?
The other party, that is not known to me, Lordship.
Okay.
However, and Lordship, thereafter, thereafter, a spot verification has been carried out by the DBs.
By DB?
By the DBs.
No, the 48 is also someone.
Yes, but after the spot verification, although there is no document to that effect, Lordship, a spot verification has been carried out by the DBs.
Where do we find any document?
There is no document to that effect. Lordship.
So how do, from where from, have you stated?
Lordship.
Para?
Para 4 of my petition, Lordship.
So spot verification was made by DB.
Yes.
In presence of party.
In presence of the parties.
You were also present.
Lordship.
So this spot verification was directed by ADC or just on the DB on its own?
Lordship, there is no correspondent to that effect. Therefore.
So you were just called.
I was just called.
To be present on the spot.
Yes, because I'm in the possession of the disputed land.
But you did not participate in you did not attend the summon.
I did not attend the summon.
Okay, but on call, you also went to the spot.
Yes, Lordship.
Yes.
Thereafter, another summon.
This was on which date? Spot verification.
Spot verification 12/10/2021.
Okay.
Thereafter, another summon has been issued. Date that is given as same date, 12/10/2021. Lordship will find this in page 48, annexure 5C.
On the same day?
On the same day.
Yes. This by this someone where you are to appear, where you are asked to appear.
Lordship, may I read the summon? In the court of DB's court Pobozu, Paul case number 1/2021, Sri Lugyavolye Lasu versus Sri Nisitwa and party, subject appeal case to Sri Lugyavolye Lasu. You are hereby summoned to appear before the court on the 22nd day of 10th 2021
without fail
at 10 a.m. without fail.
Okay.
Give under my seal.
So then what happened?
It was given by head DB, Office of the Additional Deputy Chief.
This was for what purpose?
Lordship, it turns out that on this day, the DB proceeded by started recording their statements, and on the spot itself, the DBs had pronounced a judgment.
On this day?
On this day, on the fixed date, Lordship.
Okay. So which is the decision?
Lordship, I'll come to that, but before that, Lordship, that was a verbal pronouncement. Thereafter, I've written to ADC.
It was only verbal pronouncement.
Verbal pronouncement.
Saying what?
Saying that unless I use the surname or title Merheso, the property shall not
have
be
you
given
stated
to
have you stated this?
Lordship.
In your petition?
Lordship, specifically, I have not stated the contents of the entire judgment. But yes, I have stated to the effect that the land dispute has been interfered.
Now, where have you said that the DB has verbally pronounced judgment?
Lordship, para 6, Lordship. Lordship, sorry. Para 4 and para 5 also I have stated the same. Para 4, para 5, yes.
Okay, thereafter?
Thereafter, I have written an application to the ADC asking for page 51, asking for a copy of CTC. Lordship, my apologies before going to that document. In page 49,
yes,
page 49, annexure 6, I've written to the ADC requesting, since I was taken for surprise that already the DBs had given a pronouncement of the judgment. However, since it was not in written form, I have written to the ADC.
So
may I read, Lordship?
Yes, yes.
To Additional Deputy Commissioner, Chepobozu Town, Subdivision, Kohima, Nagaland. Reference, DB's court judgment dated 22/10/2021, passed in poll case 1/2021. Prayer for taking up my appeal dated 18/2/2021, preferred to your authority against the judgment dated 9/10/2019, passed by the Nerhema Village Council, Kohima. Due respect and inviting reference to the subject cited, I, the undersigned, beg to state that I preferred an appeal dated 18/2/2021 before your authority against the decision rendered by the Nerhema Village Council, Kohima, only with regard to paragraph 4 of the judgment, order judgment dated 9/10/2019, which is as under. While deciding the instant case, the issue of Ersu and Merheso was also raised. It is decided that henceforth the parties collectively should be referred to as Merheso clan. Thus, the Nerhema Village Council, Kohima, had arbitrarily directed me to use Merheso as my surname as opposed to my present surname Ersu, which was never an issue for adjudication, as I had approached the council for adjudication of the land dispute between me and Nisitio and party. It may be mentioned that my family had been using the surname Ersu in all our official documents, which is the legitimate name of our forefathers, as the usage of the surname has been passed on from generation to generation till the present day. Therefore, I was aggrieved by the paragraph 4 of the said order in respect of directing me to use the surname Ersu. In the meanwhile, the DB's court, Chepobozu White order dated 11/5/2021, passed by the head DB office of Additional Deputy Commissioner Chepobozu in poll case 1/2021, issued summon to the undersigned to appear before the DB's court, Chepobozu, on 28/5/2021. Pursuant to the summon dated 11/5/2021, I had appeared before the DB's court, Chepobozu, on 22/10/2021. wherein, to my utter surprise and dismay, I was informed that hearing the appeal was to be adjudicated by the DB's court. Thereupon, I was asked to give my statement, which I duly complied, having no other choice whatsoever. Thus, the DB's court usurped the power of the appellate court and proceeded to adjudicate the appeal preferred by me before your authority without considering the laid down provisions and the jurisdiction, and passed its judgment against me, which is against the procedure laid down in the Rules for Administration of Justice and Police in Nagaland 1937. As such, the judgment dated 22/10/2021 passed by the DB's court, Chopobozu, Kohima in Poll Case 1, 2020 is null and void in the eyes of law. Therefore, I request your authority to hear my appeal dated 18/2/2021, pending before your authority again the decision rendered by the Nirhema Village Council, Kohima, only with regard to paragraph 4 of the order judgment dated 9/10/2019, passed by the Nirhema Village Council, Kohima, wherein I was arbitrarily directed to use the surname Merheso as opposed.
Then thereafter?
311. Thereafter, since it did not respond to my letter, I've applied for a certified true copy of the judgment and order.
Okay.
Because till this point of time, I was not given a copy of the judgment and order. This, Your Lordship will find in Annexure 7, page 51.
Okay. No, okay. You did whether the CTC furnished to you?
Yes.
Where is that?
Lordship, by hand, a copy has been given to me after this.
Okay, after this. Have you annexed?
Yes, Lordship. Annexure 1.
Annexure 1. This is judgment. Oh, this is
the DB's judgment.
Page
16.
16.
Yes.
Okay. Is this an impugn order?
This is the impugn order, Lordship.
Okay. What the order says? I think we have to take up afterwards. No? So resume it too. No?
Lordship.
So this is judgment now. Or just a minute. Okay. Resume it too. We'll resume it too.
Lordship.
You're there at 2?
Yes, Lordship.
Okay.
Family and the part of like चला की म्हणजे
tôi thì chỗ có lâu thì chỗ mà chịu chọn nè mình break của tôi mình nghĩ ini kan ini berada tak ada ya sendiri mana Beberapa bahasa itu dari kita loh orang weather dia bahasa kita jauh perlu dari itu kamu ini sampai di sini na ni orang ada di sini kalau ni itu orang orang ini kita orang na lost orang kalau bathroom mungkin dari China dan sini nanti saya orang dan dia orang saya beri brother itu beri brother oh orang dan di sini orang bina foto orang nanti kita itu tapi Kucing minta saya push tu pergi saya oh tapi itu pinot pun ada na file pergi suara lah itu kita ada rasa apa ni boleh na starting lah ada akan mati dia jadi tiga Vamos estar so rayo disposal ini proper proceedings ada CJG atau disposal or picking you are some dari office you know on a daily basis tu ada lo for kadang gue kan mulai dari before 5 to tadi gue dah lah except go na hasil Bila ini for tidak pilih for device Tuhan tahu itu, awalnya sih. Mas, nanti bersih sendiri. Ada Jerman ini.
Yes. This is over the German information.
John.
Yes.
May I proceed?
Yes.
Lordship, as stated earlier, the DB has already given a decision. And I'm aggrieved by the decision of the DB. However, Lordship, for a better understanding, may I be allowed to read the ratio part of the DB? Just the ratio.
Decision of the DB.
Yes.
Yes, please. It is page
Translated copies in page 21.
21.
I'll be reading from 23. Sorry, page 22. Page 22, last para.
This is judgment, Laura. Oh, it's long judgment.
It's a very long judgment.
DB also passed such long judgment.
Yes, Lordship.
We can read just.
Okay. However, Lordship, the facts part, the facts portion, it's a mixed up of a lot of facts which are not relevant to the present petition also, the present case.
Okay.
Yes. Therefore, in order to
DB first of all used to record the statement of the witnesses here.
there is no
Before
such
decision.
standard procedure.
Okay.
Lordship.
So how many of them used to be there? DB.
DB, Lordship,
one.
That also no. Normally there'll be a number, several DBs sitting over a case.
In a case.
Yes.
Say how many of them?
In, for example, Kohima's cases, about more than 7, 8, Lordship.
Okay.
Yes.
So all of them used to be present.
Yes.
And who is there used to be a chairman?
One head DB will be there.
One head DB.
Yes.
Okay.
And all the others are
So before decision, they should consult with each other.
That lordship, I'm not aware of the
Not aware.
procedure.
Okay,
that
here, how many
is
DB,
adopted
how
by-
many DB members here?
In this case, there are only four DBs.
Oh, okay. Yes. So relevant portion,
Relevant
which
for
one you want to read?
page 22, last para.
Last para. Okay.
No, this is the ratio.
Yes.
Thus, DB's court, Chipobozu inspected the boundaries along with the parties and the damages caused, and also checked all the documentary records. On perusing the records of the Nirhema Village Council judgment between Nodala Esu and Sri Nisityo in relation the Tepsheba issue to the order regarding the directive that both the parties should use Merheso was challenged, and also for damages of the 18 trees felled. However, after accepting the order, challenging a part of the same order is not allowed. It is an act of disregard to the judgment and order of the Nirhema Village Council. Further, Sri Lugevolya's statement in which he is ready to stand by the declaration of his grandfather Krucholye. However, as he had accepted the Nirhema Village Council, it is baseless to decide the issue. Therefore, there is no ground to set aside the decision of the Nirhema Village Council. Further, the DB's court Chipobozu on perusing the records pertaining to Mhalenhulia versus Lutyo during the 2010. The records shows that if the Merheso had been with another clan and came back to be with the Merheso, then an affidavit of declaration to the effect to be Merheso should be submitted. Such records should was also found. Therefore, next page. Therefore, Sri Lugevolya shall furnish an affidavit of declaration declaring that he is a Merheso within 1 year from the date of pronouncement of the judgment. On producing the same, the landed property belonging to Nizelhu at Tepsheba shall be given to Sri Lugevolya. However, if he failed to furnish the said documents, the landed property at Tepsheba shall become the common property of Merheso clan, and the Merheso shall not deny him when he furnished the said documents. Thus, as regards the damages of the trees at Tepsheba, Sri Lugevolya should forgive Nisityo and party. Further, as decided in the year 2010 by the DB's court in Poll Case 1 and the dispute at Tepsheba 2019 between Nisityo and Srimati Nodala was rightly decided, therefore, those orders were upheld. Therefore, on 22/10/2021, the DB's court Chipobozu passed this order between the parties. If any of the parties do not accept this judgment and go for appeal within 30 days, this order shall stand. Agreement signed. Appellant did not sign, but the respondent had signed, and the order was passed by four DBs.
So this DB is not the appellate court for the village council.
That is the ground that I'm taking before this honorable court.
Okay.
That is the only ground I'm taking, Lordship.
Okay. So, but then this DB again says that if any of the parties do not accept or agree this judgment and go for appeal. So after here, where the appeal lies? Against the DB, against the order of DB.
Against the DB or against the village council. Appeal lies before assistant to DC or DC as per Rule 31. However, regardless of whatever the DB has stated here in their judgment, my contention, Your Lordship, is that the DBs without jurisdiction has passed this order. So I'm not going into the points where whether the DB has followed the right procedure or whether law has been complied with or not.
Now, in between DB and this village council, so supposing DB pass, let us take vice versa in this case. Supposing DB, the DB can also be endorsed to, the case can also be endorsed to DB.
Yes.
The same case.
Yes, Lord.
Since it was not endorsed to DB.
No,
Supposing had it been endorsed to DB,
yes,
so it is, and then if then appeal filed before the ADC, and ADC can also, in this way, so endorse to village council.
Lordship, that is what the
No, the who means in between this DB and the village council, who is in the higher position?
they are of the same position,
Same
concurring
position.
courts.
In the
concurring
same village, two institutions
Yes,
can exist together, or what?
yes, Lordship, that is.
Say, for example, here in Kohima, DBs are there, village council are also there.
Yes, GBs are there,
GB.
DBs are there,
So,
village council is there.
So GB is a village council.
It holds the same rank as the village council.
But they are not
Otherwise,
together.
even the GBs can also
Whether they
decide.
sit together sometime, no.
Sometimes they are together, but they can decide cases separately also, GBs and the village council. But in some villages, the village council along with the GBs will sit together and decide matters.
What they name it, DB or GB?
Lordship, as far as my knowledge goes, in one case, I have knowledge in only one case. It was under village council. Yes. Although GBs were also present. Lordship, as per
Decision was as a DB. Although the GBs were also present.
Yes.
So in that case,
yes.
So it was in the decision.
Yes.
It was like here ordered by DB's court.
Yes.
So it was orders by DB's court or
no, not DBs, not DBs. Village council.
Village council.
Gamburans and village council, GBs and village council, they sat together, and that order was pronounced as.
Gamburas are not village council.
They in that very case, Lordship, which is not before this honorable court now, but GBs and the village council, they sat together as a court, and then when the decision came out, it was in village council's name as a village council decision.
So GBs are not village council.
Lordship, as per rules.
As per rule.
As per the rules, under Rule 31 also, GBs, village council, the village authorities, the DBs, they can take up matters separately.
Where
but
do we
all
find
of
that?
them are concurrent courts, Lordship.
31.
Lordship, in 31 also, you'll find that, Lordship. Lordship may kindly see Rule 24 also. For that purpose. Page 28. Rule 24. Mauzadars, Gamburas, chiefs, headmen of Khels, Dubashis, or other village authorities sitting with the village elders in council are empowered to try cases without limit as to the amount, but with the following reservations. So they are concurrent courts, Lordship.
So in a same village, this Mozidar, Gamburas, chiefs, headmen, or headmen of care and Dobases, all can also be together. Together means they can exist.
Together they can exist, Lordship. They can exist together.
So anyone can, supposing a complaint can be filed before the Mozidar also, before the Gamburas also, and before the Dobasis also.
Yes, Lordship.
So
but
it's not that First, you have to complain before the Gamburas, then with the bus.
No,
It's not like that.
The litigant has the option of either go for the DB's court or GB's court or village council court. However, in Nagaland context, as far as the DBs are concerned, Dubashis are concerned, each village does not have its own GB's court, but collectively, for example, in the instant case, the GBs of Chepobozu has decided the matter. Under Chepobozu block, there'll be a number of villages, more than 10 villages. In the same manner, in Kohima town,
But GB has power and authority or jurisdiction within his village only.
Yes.
GB.
Yes, Lord.
Okay, so Devasis has a larger jurisdiction.
Lordship, I don't have a clear provision to assist this honorable court on that, but yes.
Okay.
Normally matters.
Okay, so you're agreed by this?
Yes, Lordship. And
just
I'm placing reliance on two judgments of this honorable court.
Just
2000.
Just a minute.
Lordship.
This was decided on 22/10/2021.
Yes, Lordship. The DB's decision.
Okay, yes.
That's GL 2021 for GLR 248.
Give the better give the copy. Can't carry this. Okay, two.
This is a division bench decision.
21.
I'm relying on para 16 onwards.
8.
Para 16, 7, para 16, 17, 19, 20, and 23.
Okay, so.
May I read, Lordship?
Yes, please.
Para 16. From the literal reading of the provision of Rule 31 with respect to the appeal before the DC, ADC, or his assistants, it is clearly discernible that 1. When an appeal is brought before the DC, ADC, or his assistants, the court shall examine the parties, and if the decision appears to be just, shall affirm and enforce it as its own. Number 2, if the court sees reason to doubt the justice of the decision, it will try the case de novo, or 3, refer it to Panchayat as above. Thus, the plain reading of the provisions of Rule 31 does in any way give authority to the DC or his assistants to forward cases of appeal to any other court but to Panchayat. Therefore, an appeal forwarded to the court of Dubashis from the decision of the village court is divorce the provision of the appeal rules of 1937 Act. The Rule 31 is crystal clear that when appeal is preferred from any of the Mausadar, chief, headman of Khels, Dubashi, or other duly recognized village authority, it will, if satisfied, enforce it as its own. If it has a reason to doubt, it will try the matter de novo or endorse it to Panchayat. The DC or his assistants will either try the appeal petitions de novo by itself or refer the same to the Panchayat from the decisions of all recognized courts, including the decisions of the Dubashis. The above being the clear provision, the act of the EAC of referring the appeal of the Dipupar Village Council to the Dubashis Court, Chumugelima, was violative of provision of the appeal under Rule 31 of the 1937 Act. Coupled with above provisions, Rule 24 provides 24 Mozadar Gampura's chief headman of Khels. Yes, same as that.
Yeah.
And in the next para, Lordship, the above provisions provides that the Dubashis court and the village court, including all the courts below the assistant to DC, have concordant jurisdiction. It could not be the intention of the legislation that the appeal could be preferred from the judgment of a court to another court with concurrent jurisdiction. Meaning of appeal is defeated by such an arrangement. Should there be any confusion while interpreting the provision of the Act rules, it has to be interpreted in the manner that it should be in conformity with the general law. The controversy being an issue of the civil procedure law, it must be in conformity with the provisions of the CPC. The schemes of the CPC is that the appeal is always before the court of a superior authority. The provision of the appeal under 1937 Act must also be interpreted in the same manner. 17. Rule 23A provides that the Dubashis henceforward shall try and decided case such civil cases as may be referred to them by the Deputy Commissioner or additional Deputy Commissioner or Assistant to Deputy Commissioner as the case may be. It does not speak about the cases which comes on appeal from the lower courts. Obviously, the court of the Dubashis, village court, headmen of Khels, Muzadars, etc., recognized under rules are the lowest courts in the scheme of 1937. A reading of Rule 55.1 provides the district customary court shall be the court of the appeals as against the decision of the subordinate district customary courts and village courts in suits, and both civil and criminal decided by the said courts. The district customary also may try suits and cases triable by the subordinate district customary courts as and when occasion arise. That the next is not very relevant, so I'll go to 18.
Yes.
The provisions relating to appeals under Rule 1937 may thus be summarized as follows. Appeals from the court of Dubashi's village court or other recognized courts is brought before the DC or ADC or his assistants. It may be tried de novo if doubt arise. It may be referred to the Panchayat, not to any other authority. Appellate courts from the decision of the village courts will be the district customary courts. 19.
Okay, 18 also you have read.
Yes.
So it should be 18 also. Okay.
19 has your lordship go.
Yes.
Under the Rule 31, the word used is shall, which indicates that the rule must be meticulously followed. There is no room for any other procedure, anything beyond which is provided under Rule 31 in case of appeal from the village courts and other authorities is prohibited. Therefore, DC, ADC or his assistants cannot refer cases which come on appeal to them, save to the Panchayat. The provisions under Rule 55, next para is not very relevant, so I'll skip that. What is then the use of Rule 23A? The only answer emanating from the reading of the various rules under the 1937 Act is that it is a provision inserted for enforcing DC, ADC and his assistants to exercise supervisory authority in matters relating to cases of original jurisdiction in the DB's court. There is nothing further expendable. It's only for original jurisdiction cases.
Yes.
20, Lordship. From the above the discussion, we hold that Rule 31 of the Rules for Administration of Justice and Police 1937 does not provide for appeal against the decision of village courts before the DB's court.
Yes.
And Lordship, in para 23, the second and third paras are not very relevant. That coming to 23, this is the decision given. Having discussed the points of reference, we now answer the issues of reference as under. Dubashis cannot be empowered as appellate court by the exercise of powers under Rule 23A. Rule 31 debars the DC, ADCs and his assistants from such authority.
Yes.
Lordship, in the present case, the respondent authorities.
A similar case.
Yes, they are taking the ground that the ADC has referred the matter under Rule 23A. However, it's clearly decided that even in such cases, since the Dubashi is not an appellate court, the DBs cannot.
Jurisdiction of the court cannot be empowered.
Yes.
Yes.
Yes. Lordship, the second case that I'm referring to is
cannot be empowered to the court, subordinate court.
Yes. I may be given a moment, please. Okay, Lordship, in this case, I'm relying on para 13. Para 13, 16, 17, and 21. Also, I'll find page 7 of 15, 7. Para 13. May I read, Lordship?
Yes, please.
In para 13, there are number reference the judgment has been referred to. There were
decision of the Supreme Court.
Several decisions of the Honorable Court. However, Lordship may kindly see in page 7.
Yes.
Yeah, in the middle para. In the case of Jagmitar Sain Bhagat and others versus director.
Jagmitar Sain, okay. Yes.
Married. In the case of Jagmitar Sain Bhagat and others versus Director Health Services, Haryana and others reported in 2013, then SCC 136, the Honorable Supreme Court held as follows. Indisputably, it is the settled legal position that conferment of jurisdiction is a legislative function, and it can neither be conferred with the consent of the parties nor by a superior court. If the court passes a decree having no jurisdiction over the matter, it would amount to nullity as the matter goes to the roots of the case, of the cause. Such such an issue can be raised at any stage of the proceedings. The finding of the court or the tribunal becomes irrelevant and unenforceable, inexecutable once the forum is found to have no jurisdiction. Similarly, if a court tribunal inherently lacks jurisdiction, acquiescence of parties equally should not be permitted to perpetrate and perpetuate defeating of the legislative animation. The court cannot derive jurisdiction apart from the statute. And Lordship may kindly turn to page 10, para 16.
Yes.
It is, that's your Lordship code.
Yes.
It is relevant to refer Rule 23A of the Rules for Administration of Justice and Police in Nagaland, Second Amendment Act 1982.
Yes.
Which reads as follows: the Dubashis henceforward shall try and decide such civil cases only as may be referred to them by the Deputy Commissioner or Additional Deputy Commissioner or Assistant to Deputy Commissioner, as the case may be. What Rule 23A postulates is that Dubashis shall try and decide only such cases as it is referred by the Deputy Commissioner, Additional Deputy Commissioner, and Assistant to Deputy Commissioner, as the case may be. In other words, the Dubashis now cannot try any civil cases on its own, except those referred by the authorities prescribed in the rule. It is further important to note that Rule 23A has not given any power to the Deputy Commissioner, Additional Deputy Commissioner, or Assistant to Deputy Commissioner to empower the Dubashi to act as an appellate court authority. Therefore, Dubashis, while adjudicating a case on reference, cannot exercise the power of an appellate court.
Yes.
And 17, there's a reproduction of the rule, and then in the next para, in the case of Gokishe Chopi Supra,
yes,
the learned coordinate bench of this court has also held that Rule 31 of the Rules for Administration of Justice and Police in Naga Hills District provides that appeal shall lie from the decision of the GB's chief and headman of hills or any other duly recognized village authorities of the Deputy Commissioner or his assistants. There is no provision for preferring an appeal to the DB's court against the decision of the village council, village court.
Yes.
The appeal lies with the Deputy Commissioner or his assistants. There is no provision under the rules that appeal against the DB's court shall lie with the political assistant to Deputy Commissioner of the district. The political assistant, in fact, is not the court and has no authority to exercise the judicial power in the state. Therefore, the order passed by the DB's court as well as the political assistant to Deputy Commissioner are without jurisdiction and not tenable in law. And in 21, the decision, para 21, page 14. Since the other paras are just a more or less 14. A repetition of others.
Para?
Para 21, page 14.
Okay.
In the light of discussion made above, and having held that the DB's court under the rules has no power to review or sit in an appeal over the decision of the GB's court, the judgment and order dated so and so, passed by the learned assistant to Deputy Commissioner Kohima in civil appeal number so and so, questioning and setting aside the order dated so and so, passed by the DB's court in poll case number 7, 2019,
yes,
is upheld.
Okay.
Your Lordship, therefore, my prayer before this honorable court is that since the DBs without jurisdiction has adjudicated the matter as an appellate authority, the same may be questioned set aside.
Yes.
That's all for my submission.
Your for respondent number?
I'm for the state, my lord.
I'm sorry. State. Yes, yes.
1, 2, and 3.
Okay, okay, yes.
My lord, before I make my submission, your lordship may kindly see my affidavit in opposition. I'm relying on para 4 and 5.
You find affidavit in opposition also.
Affidavit in opposition filed on behalf of respondent number 1, 2, and 3.
Affidavit in opposition there. Is there? No, sir.
1, 2, and 3.
Okay. On behalf of respondent number 4. No, where is 1, 2, and 3? Affidavit in opposition to respondent number 1, 2, and 3.
One, two, and 3.
It's not there. Not here either. There is an affidavit in opposition on behalf of respondent number 4. Is available, but no, it's not there. Do you have extra copy?
I filed on 4/5/2023. You can take this one.
Para 4.
Para 4 and 5. I'm
4 and
relying
5.
this, yes, para 4 and 5. Can you allow me to read this paragraph, my lord?
Okay, yes. Please.
Para 4. That with regard to the statement made in para 1 of the instant petition is denied. The answering deponent humbly beg to state that since the petitioner is aggrieved by the judgment dated so and so passed in connection to so and so passed by the village council, especially in para 4.
Yes.
The petitioner ought to have filed review petition before the same court, but he had filed appeal before the answering deponent, the additional deputy commissioner, Chububuzo. However, after thorough examination of the petitioner application and the matter was entrusted to the DB's court, Chububuzo under Rule 3A to settle the matter or issue before the issue is related to the use of the surname or title Yuso and Meherso. It is pertinent to mention herein that there is an issue of surname in the said village, and earlier also DB's court of Jobobozo had settled the matter, and the decision were adhered in the village till the present issue rise again. Whereas the main issue or dispute of the subject matter is a land dispute at the Tirpriba decided by the Neherma Village Council on 9/10/2019 between the petitioner and respondent number 4, Sri so-and-so, and the Village Council has decided on 9/10/2019 to let the petitioner use the surname Meherso instead of Yuso and take ownership of the disputed land as mentioned in point 4 of the judgment. Thus, the matter was not entrusted to the DBs of Jobobozo as per Rule 31 to hear the matter as appeal case, and therefore allegation that the matter has taken up by the DB's court Jobobozo to decide the matter as appellate court is denied in toto. That on perusal of the DB's court dated 2010,
Just a minute.
2021. Yes,
Pause
brother.
for a moment. So while endorsing the
Yes.
case to the Dubases,
Yes.
whether the ADC has made that is should be treated as review something.
Yes,
like,
no, my lord.
because it was appealed.
Yes, I'll come to that, my lord. I'll
Okay.
come to that. Let me read out this all, but I'll justify.
Okay.
That on perusal of the DB's court dated 22/10/2021, it is mentioned that earlier also there is an issue of using the surname of Yuso and Meherso between the petitioner and respondent number 4. The matter was heard and resolved by the DB's court, Jabobozo order dated 9/10/2010 in political case number 6 of 2010. And both parties has agreed to the decision of the DBs, and in compliance of the said order, the petitioner had executed affidavit of change of name on 3/12/2012 before the notary so and so. In the instant issue, also DB's court, Jabobozo has settled the matter earlier, similar to the village council decision dated 9/10/2019, and according to the decision of the earlier settlement of the DB's court. Number para 5.
So that means there was an earlier decision also.
Earlier
in connection with the same.
Yes,
case.
yes, my lord. I'll come
But
to
it is
that.
not on record.
It's there. It's there.
No,
my lord.
in the instant case.
Yes.
In the decision of the the buses,
Yeah.
whether this case has been referred or mentioned.
Yes, my lord. My lord, I'll come to that.
Okay.
Kindly allow me to read this para, the
Okay,
last para 5. That with regard to the statement made in para 2, 3, 6, and 9 of the instant petition, the answering deponent humbly beg to state that the issue or subject matter placed before.
Now we are reading.
Para 5, my lord. Para 5.
Okay.
Para 5. Village council is pertaining to ancestral property at Tepriba, and the matter was heard and decided as per the agreement dated 29/11/2002 to give the disputed land be given to the petitioner, and he must use the surname Meherso, to which the petitioner has agreed to the decision of the village council, giving the title of ownership to the land. But after 2 years of the village council decision, he is disagreed to use the title Meherso and place the issue before the office of the additional deputy commissioner Jabobozo, which was heard and decided by DB's court Jabobozo. It is observed that the use of title is connected to the land in dispute between the land is ancestral property of Meherso. However, the petitioner is using the surname Yuso, which he says is the name of his great-grandfather, and he do not want to use the surname Meherso. Therefore, liberty is given to the petitioner whether he wants to inherit the property or land at Tepriba by using the surname Meherso, or choose to use his present surname Yuso and give up his rights to the Meherso property. Thus, the respondent authority has decided to let the Meherma Village Council or the DB's court to settle the matter as per the previous decision as agreed to or followed complied in the village. My lord, here, the petitioner has made submission that he is aggrieved by the village council, Meherma Village Council decision. Your lordship may kindly see in the petition, page number 26, in the writ petition.
26.
Yes, 26.
Yes.
Now the petitioner is saying that he is aggrieved by only para 4.
Yes.
The rest is in his favor.
Yes.
And by seeing the order, it can say that it is that this order was passed beyond the bleedings, because he said that this in regard to surname was never contended before the village council. And now whether the appeal can be filed basing on this order or not, because whether the appeal can file challenging the certain portion of the order. So since the petitioner has challenged only the aggrieved portion, that is para 4. So if he think that it is beyond the pleadings, it was decided, it was never contended before the village court, then he should file appeal. No, he should file review of this order. But he has not filed, instead of filing review, he has filed appeal before the
No, whatever may be, rightly or wrongly, he has filed appeal.
Appeal, yes.
He did not file review.
Yes, he filed appeal.
But then could have rejected.
Yes.
Could have the appellate authority could have rejected if he think that no, only the partially we cannot pass order.
Yes.
For the half of the impugned order.
Yes.
Or with justification, whatever may be.
Yes.
But then why he had to endorse to the Devasi, who doesn't have a power and jurisdiction to decide?
Yes, that
he
order
should have decided.
Yes.
Had he decide, it's fine.
Yes.
But he did not decide. The question here is only that whether the Dabasi has an appellate power or not.
No,
It appears.
No, my lord. As per the rule, Topasi has no appellate authority.
Yeah, that is why.
Yes, my lord.
So I
But
think
my lord,
here,
yes.
the decision, let it stand wherever may be, okay. But then for the time being, for the present, in the instant case, only the question would that whether the Dabasi has the appellate jurisdiction or not, whether the Dabasi can decide the case in the appellate as an appellate authority.
As per the rule, no.
No.
Dabasi has no jurisdiction.
I think in the here limited. I think here limited issues.
Yes, my lord.
In
But
the instant
here,
case.
your lordship.
No,
here-
not the fact, not the
Yes.
fact of the case.
So, though it was filed before the appeal was filed before the ADC, he thought that since it is challenging the only the person,
right.
person, so he intros the case to the TB's court,
But
not to trial as an appellate court, to adjudicate as a.
No, where is do you have the order?
Yes, that order is not there, but it was intros to the under Rule 23A, because under Rule 23 it says
under
that
Rule 23A, it was already decided by the village authority. The
No,
earlier
DB's court.
order.
TB's court can.
No, not the DB's court. Earlier order. Where is the earlier order?
No, my lord.
So that is
your lordship may kindly see that Rule 23A.
Yeah, Rule 20 as per Rule 23A, as and when any complaint filed,
Yeah.
the DC or ADC can endorse to the buses or to the village authority to anyone. So 4 of them. Anyone.
No,
So
under Rule 23A, only to the Dabasi court.
Only to the
Dabasi, not the village court.
Let us see.
And my lord, that Rule
Let us
23,
see. Let us see.
23A.
Oh, this was 24.
23.
Yes,
23A.
I was talking about 24.
Yeah.
Right, just a minute, huh? 23?
A.
Yes. Let us see, 23A.
The Dabasi henceforward shall try and decide such civil cases only as may be referred to them by the Deputy Commissioner or additional Deputy Commissioner or assistant to the Deputy Commissioner as the case may be.
That is the new complaint.
Yes.
New cases came up before them. They can endorse it for the decision. But then here is the case where it was already decided by the village authority, by the GB. So he cannot endorse to re-decide. This is not for the re-decision.
Yes,
it has come for the appeal.
Yes, as per the our submission is
it has to be fair.
Yes, under this rule, under 23A, the ADC has entrusted to the DB's court.
No,
and
it did not mention. No.
Yes.
So the case has already been decided. He has cited, he has enclosed the order of decision also and says that this is appeal. He has clearly mentioned it's appeal. Could have rejected or could have refused to accept also if he don't want. But then you endorse to the person who doesn't have a power and jurisdiction to decide a case. He has a power. He has a power to reject also. He has a power to set aside quas or whatever may be, dismiss also. But then he has no power. He has endorsed to the person or endorsed to the authority who doesn't have a power and jurisdiction to decide. So that is the question here.
Yes,
limited question.
Yes, as per our submission,
yes.
according to our submission, it was entrusted under 23A.
No, where?
Yes.
Where from you are submitting?
No, I in my paragraph I have stated in my paragraph.
In the paragraph.
Yes.
But then nowhere it is stated. The ADC has nowhere stated.
No, my lord, in the
at the time of endorsing, whether is there any
that
letter?
endorsement is not there.
No, not there. Then in that where from you are submitting?
In the affidavit paragraph
no,
stated.
You just tell me. Can the already decided case? Can the ADC re-endorse for re-decision?
My lord, since the ADC thought that
no. Why should we think? Why should when he should have understood this is
without taking his decision, he thought that it should be filed.
No. That way
it was endorsed.
No. How do we explain in that way? So
that is the that is the justification. So and my lord, secondly,
it is under the law.
Yes.
Under the rules. So when he has decided, so it has to be as per the law only, rules only. So what do you think cannot? Okay, so who is?
Yes, my lord, in regard to the facts, my lord.
Okay, the fact we can't. fact, they have already decided. Fact, he is or he, fact, we have understood. Here in the appeal, only whether the Dobasi has the power. For the time being, we'll not go to the facts here at the moment because he has not decided. The authority who has the appellate authority has not decided. It is challenging the decision of the Dobasis only here in this case. So it can be sent back or whatever maybe, but then if he decides, well and good. But then this Dobasi doesn't have a power, appellate power.
Though, as per the rules, Dobasi has no jurisdiction.
No. Okay.
But
So
it was acted under rule in the trade.
Right.
That is our submission.
Right. Okay.
That is our submission.
Okay. So respondent number. Yes. You have anything to submit?
Your Lordship, the petitioner had already briefed out about all the facts of the case.
Yes.
And although I have some submission to give on behalf of the respondent number 4.
Yes.
Your Lordship, the petitioner had mentioned that the subject matter of the case, which was placed before the Nirma Village Council, it was solely on the subject matter of ancestral land. However, Your Lordship, I submit that the subject matter is not inclusive of the ancestral property, but it is inclusive of the subject matter of the usage of surname also. And since the ancestral property here is the ancestral property of the respondent's clan, that is the clan of Mereso. Your Lordship, the reason why the subject matter of the usage of surname Mereso is attached and is inclusive in this land that was partitioned is an ancestral property of the respondent clan and not the ancestral property of the petitioner's clan. Your Lordship, here the petitioner also mentioned that partition has already been made. Yes, Your Lordship. The respondent is not denying that the agreement of partition has been made between the petitioner and the respondent. However, and also, Your Lordship, the village council already decided in favor of the petitioner. Your Lordship may also consider the fact that the partition of the ancestral property that was made in the year 2002 was amongst the member of the Mereso's clan, and in pursuant of which the petitioner was also given a portion of land by through the ancestral property of the Mereso's clan. However, Your Lordship, the petitioner had never actually accepted Mereso as his surname in respect of the land which lies within the jurisdiction of the Nirma village. Your Lordship, in respect of the land which lies within the jurisdiction of the Nirma village. Your Lordship, in pursuant to this issue of continuous issue of surname, and by virtue of which the petitioner's clan held a meeting. Because of this issue, the petitioner's clan had held a meeting and passed a resolution in the year 2002. Your Lordship, may kindly see page number 40 of the affidavit in opposition, annexure D.
Page 40. What is that?
Your Lordship, this is the general meeting that was held after the partition of the ancestral property. Since the subject matter of the usage of surname has been made and as an issue. So in this general meeting, the respondent clan had held a meeting and it had come up with 4 resolutions. Your Lordship,
general meeting.
Yes, Your Lordship. Amongst the clan member of the respondent. May I read, Your Lordship?
Okay, clan member of the respondent.
Yes, Your Lordship.
Okay, as well as the petitioner.
Yes, this was made known to the petitioner and also to other clans also, to every clans also.
Okay, yes, please.
Mereso clan, that is the respondent clan, they held a meeting and resolved the following decision in respect of the clan common lands. 1, that the general meeting decision dated 22/3/2003 shall remain inactive until any further general meeting. 2. That any member shall not be sold out or let the common land without the consent of the clan, without the consent of the Meresos clan. 3. That in the event of any family or individual renounce the clan shall be seized from the member to the common property/land. 4. That any original member who had ceased, renounced the clan, and whereof released to reunion with the clan shall be reconsidered provided prior approval of the clan.
When this was decided?
2003, Your Lordship.
2003.
Yes, Your Lordship. Because of the
Then,
continuous
when the land was given to the
2002, Your
petitioner,
Lordship.
2002.
Yes, Your
So
Lordship.
it was after giving, after
Yes.
sharing away of the
Yes, Your Lordship.
property to the petitioner.
Yes, Your Lordship. The ancestral property was partitioned amongst the member of the Meresos clan. And in pursuant of this, the petitioner also
See, prior to this decision in the year 2003, the petitioner has already received the said property in the year 2002.
Yes, as part and parcel of being a member of the Meresos clan, Your
Yes.
Lordship. Being a member of
But
Meresos
there was
clan.
no condition in this that he should adopt the title or the surname Nesito. What is
Your Lordship,
Mereso?
in support of all these facts, if I may take the support of the decision that was passed by the DB's court in the year 2010.
Okay.
Your Lordship, this.
The basis.
Yes, yes, Your Lordship.
So,
Your Lordship, the decision is lengthy, so I'll just brief out the decision that was passed in the year 2010. Political case 9 November 2010. Your Lordship, here, the same, even in a similar situated case, in the year 2010, the subject matter of partition of land and the usage of surname were placed before the DB's court at Chipobozu. And the dispute was between parties of clan, Malilulye and party and Lutyo, over the subject matter of ancestral land and subject matter of the usage of surname Mirheso. Your Lordship, it is a fact that even in this similar situated case, both the petitioner and the respondent are also a party, though the name of the parties has been reflected as Mahaleluli and parties and Lutyo. Your Lordship, here in the year 2010, the main issue which arose is out of two factors. One is issue of partition of land, because those members who adopted another clan instead of their birth clan, they started to distribute land among themselves without the consent of the Meresos clan. And second, selling and disposing of ancestral property by those members who adopted another clan instead of their birth clan, who are not of Meresos clan. Your Lordship, here the fact is the issue was brought before DB's court since Lutyo, I'll refer it for easy understanding, I'll refer to him as the respondent, who adopted another clan, had sold of the common property of the Meresos clan to the Nirhema model village. And the DB court decided that Lutyo will pay amount of 1 lakh to the Nirhema village and retain back the land to the Meresos clan. But the respondent here, he did not comply with the order of DB, nor did not file any appeal before any forum. Your Lordship, therefore, the DB decided that the Lutyo will not longer have its share in the common property of the Mereso. And in this way, the order of the DB still stand today without any objection from any member of the clan. Your Lordship, here.
With regard to that, another clan?
Yes, Your Lordship.
Not with this clan?
Your Lordship, this inclusive of all the clan, because Your Lordship, the DB's court in this year had passed an order for the welfare of all the clan. Your Lordship.
DB's of which village?
Nirhema village, Your Lordship, Nirhema village.
Not the present village.
The present village, where the jurisdiction of the
present village.
Yes,
DB.
Your Lord. Yes, Your Lordship. Your Lordship.
Can that be a precedent? DB's decision?
Yes, Your Lordship, all the parties here, the clan are relevant, Your Lordship. The members of the clan of Mereso as well as those who have adopted another clan, they are all relevant here in this instant case. And the DB's court had passed an order in respect of for the welfare of all the clan members. Your Lordship, I may be allowed to assist.
Have you annexed that as a relevant document?
Yes, Your Lordship.
Annexed?
Yes, Your Lordship.
Yeah.
Yes, Your Lordship. Your Lordship may kindly come to page number 23. Your Lordship,
Yes.
I'll start from para 2. The second para, further. Further submits that the statement and words spoken recorded from Sri Mahaliluli and parties, Lordship, it is mentioned and parties, and Lutyo and parties were said to be alike and reliable to each other. And during the time of partition of the plot of land, the children of Lutyo had parted the land only with those people who are not of Mereso's clan, and that such partition was done without those who truly belonged to Mereso's clan. Hence, the distribution of the land among the children of Sri Lutyo and those belong to other clan was held completely wrong. Therefore, the issue pertaining to the distribution/parting of the said land should not be made as a subject matter. It is decided that no one other than Mereso's clan shall be allowed to cultivate in the said land, nor sow or drink anything from that land without due permission of the bona fide members of the Mereso's clan. Further to that effect, it is directed that unless and until a clear affidavit in non-judicial form is furnished by both the parties shall have no right invested to neither sell nor enjoy the said land in question. Also bringing to notice to Sri Mahaliluli and parties and those who had been with another clan. Your Lordship, significant may be given to this particular sentence.
Is this the same clan?
Yes.
We are talking about.
Yes, Your Lordship.
And
Mahaliluli and parties and those who had been with another clan other than
is this the
Mereso.
same clan that we have here, the petitioner and the respondent?
Your Lordship, here in this instant case, there has been issues that those.
No, my question is.
Yes, Your Lordship.
Specific question. So we have here.
Yes, Your Lordship.
Two clans.
Yes, Your Lordship.
They say to be the brother, Uso, and
Mereso.
Mereso.
Yes, Your Lordship.
So, but this is some other clan.
Your Lordship, here, this is in respect of Mereso and Jepra clan.
Not the Uso and the present one.
Yes, Your Lordship. But
okay, different.
Yes, Your Lordship. The issue here is.
So this decision is with regards to the another clan.
Yes, Your Lordship. But then, Your Lordship, even in the past, those who truly belong to Mereso, they have been adopting different.
So we are not on that. What I am saying here in the present case.
Yes, Your Lordship.
In the present case, it may be sent back. It may be it may be, of course, for the decision for the appellate court, or
yes,
appellate court may reject. Okay.
Yes, Your Lordship.
But not on the fact.
Yes, Your Lordship.
Here the challenge is the issues is only on the jurisdiction.
Yes, Your
of the present court, who has decided sitting as a appellate court. Whereas he doesn't have the versus doesn't have the appellate authority. Only with that regards, not on the fact. On the fact, you may be correct. That will stand. Probably that will stand. But then the authority, the decision, the impugn order decided by the Dabasi, who doesn't have appellate authority. So you have anything to say on that? In fact,
yes,
you are correct, because the decision is there. So he is challenging in the fact that will be decided by the proper authority, the authority having jurisdiction that will be decided. And you have also the village authority has already decided on fact. Okay. And then in the appellate authority also, decide a case appreciating the fact of the case. But here the case where the challenge is only with regard to the authority of the Dabasi.
Yes, Your Lordship.
That the Dabasi doesn't have the appellate authority.
Yes,
you have anything to submit on that?
Your Lordship,
In the
basing,
fact, because here in this case, fact may not be required to
Yes,
discuss
Lordship.
also. Here in this case, fact may not be required to discuss also for the decision of the this particular case.
yes, Your Lordship.
Hmm.
Your Lordship, I may take the stand of this, its stand order. Your Lordship, this two
That is on
thousand ten
fact.
order.
That is on fact with regards to the say adoption of the
Yes.
surname.
Yes,
And
Your
until and unless he is ready to adopt the surname,
Yes,
he is not entitled to the ancestral property.
Yes, Your
That is correct.
Yes, Your Lordship.
But the decision here, who made the decision here? Who sat in the appellate authority? Who doesn't, the Basi, who doesn't have the jurisdiction to sit as a, to decide as an appellate authority? He cannot reappreciate because the decision has already been taken by the village authority that he has to adopt the surname of, he has to say it away with the so.
Your Lordship, regarding that,
So you have any power to show that the Basi has appellate authority to decide,
Your
and she
Lordship,
has the appellate authority?
regarding that, the respondent is of the view that, with respect to the judgment on the, regarding the appeal, uh, we have, the respondent have no comments to offer and undertake the law to take its own course.
Okay.
But one thing I want to make clear before this honorable court is that it's totally the fact of the case.
Fact of the case
That
is correct. I have understood.
The petitioner has complied with the decision that was passed in the year 2010. The DB's court had decided that those who have adopted another clan, if they wish to come back, they have to furnish an affidavit. And likewise, the petitioner also complied with it.
Within a year. Here in this case also, within a year, he has to furnish affidavit
Yes, Your
declaring
Lordship, yes.
that I'm
It was on
adopting
the
this,
strength, yes.
I'm adopting this surname, and then only he will be entitled.
Yes.
So that is the another, that will be decided by another forum, whether you can compel him or not.
Yes, Your Lordship.
But then for the timing here, in this case, I think we'll, with the limited issues, we'll have to decide and then send back. Okay.
Your Lordship, my
Yeah.
lord, only one.
Yes,
question,
yes,
my lord.
please.
Your Lordship, may kindly see the prayer version, my lord.
Yes, of course.
In the writ petition.
Read petition.
Yes.
Prayer may be more, but
Yes,
then
my lord, in
will
the
be
prayer,
decide-
in the prayer, he has made only specific prayer, that is.
Okay. Yes.
May I read, Your Lordship?
Yes, please.
Wherefore, on the premises aforesaid, your humble petitioner most respectfully pray that your lordship may be pleased to admit this petition, call for the records, and issue notice calling upon the respondent to show cause as to why the impugned decision dated so and so passed in political case number so and the insofar as of the
Parafour.
yes, my lord, parafour. Here also he is challenging only the specific. Only the specific
Yeah,
portion of the
specific.
judgment.
So
yes.
in this specific challenge, in specific issues, the appellate court should have decided. But then here is a case where appellate court has not decided. Appellate court has endorsed to the court or the Dabasis who doesn't have the appellate authority. So that, so it's a decision by the wrong forum, endorsed to the wrong forum, who doesn't have the jurisdiction. So his limited prayer is to decide on 4 only. Now here comes that okay. So I'll
That's all,
take
ma'am.
the fact, take the fact, and then
I'll leave it to your lordship.
yes, okay. What I'll do is hard. Mr. learned counsel for the petitioner. Stop. I've also heard.
E.T. Pakum for the state respondent 1, 2, and 3.
Okay, for status from 1, 2, and 3. And Miss
Krieke.
for respondent number
4.
4. Stop. Fact of this, I think. Okay, fact also I'll record it later on only. Hearing concluded, judgment reserved. These two kindly step and keep here. So there. And this also I'll record these two also. This, if I can get the Xerox copy so that I can carry. This probably I have there. Make it copy.
Whatever that's.
Oblige, Your Lordship.
May 5th December, respondent number 1, 2, 3. We have the respondent number 3 other circulate. No, someone like that.